Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, on first time of business with the Appellate Division, drawn here, in attendance, and shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. Most of you know the drill. I'm going to call the calendar. I'm going to ask you what time you need. Not the time that you want, the time that you need. Understanding that we are familiar with the briefs and the record, probably more than you wish we were. Okay, so please understand that if we were to grant all the time requested, we'd be here until midnight. So, and I can assure you that the people at the end of the calendar will not be happy about that. So, also understand that the light is for you, not for my colleagues. So if you are brilliant in your argument and my colleagues have more questions, I let the argument continue, all right? People versus Diawul Haz Bawa. Good afternoon. 6 and 2, okay? All right, 6 and 2 and 6. Kane versus 42 West 65th Street.
Appellant, Your Honor, request 7 and 3.
Responding, Your Honor, 4 minutes.
All right, 5 and 2 and 4. H Children, submitted. Adcmin versus DHCR. No rebuttal time? No. Okay.
Respondent, Division of Housing and Community Renewal, 3 minutes.
All right. 6 and 3. Segoy versus Danella Construction. All right, and you are for which appellant? Okay. All right. And you want what? Okay, that's a lot of time. Okay. So we're going to do 5 and 1 and 5 and 1. Sullivan versus Uber Technologies. I understand that Mr. Isaacs is on his way. How much time would you like?
Good afternoon, Your Honor. This case settled in...
No, it didn't settle. I don't have a written document of settlement, and until there is one, we are arguing this case. How much time would you like?
We request that the case be submitted with that argument.
I have Mr. Isaacs on his way. So how much time would you like? One more time.
6 and 1, please.
Okay, 6 and 1, and 7 for Mr. Isaacs. And we will call that once he gets here. People versus Jose Pichardo is submitted. People versus Jean Guillén Beltri.
Appellant requests 5 and 2, Your Honor.
Okay. 5 and 2 and 5. Payano versus Prado Property Services. Submitted. Karanevik v. Haas. Have I so mangled the name that, that you don't recognize your case? Versus Haas? No? Okay, submit. Surprised. People versus Anthony Grant. Okay. 5 and 1 and 5. T. Lillette versus Simone G. Submit. Okay. Nadler versus Carmine Limited.
Good afternoon, Your Honor. Appellant request 6 and 2.
Okay.
Good afternoon, Your Honor. Respondent requests 5 minutes.
Okay, 5 and 2 and 5. People versus Jeffrey Rodriguez. Submit. Owens versus Braun is a submit. People versus Anthony Barlo.
Good afternoon. Ms. Barlo asked for 5 and 2.
How much?
5 and 2.
Okay.
And respondent requests 5.
All right. Let's do 4 and 1 and 4. And like I said, if you're brilliant, we'll keep going. Okay? All right. Crandle versus Equinox Holdings.
Good afternoon, Your Honors. Appellate request 7 and 3.
Okay,
Good afternoon, Your Honor. Respondent request 6.
all right, 6 and 1 and 6. Anonymous versus Anonymous.
Good afternoon, Your Honor. Appellant request 6 and 2.
Okay,
Good afternoon, Your Honor. Respondent request 6.
6 and 1 and 6. People versus Ernest Sobrianes.
Good afternoon. Mr. Soanes request 5 and 2.
Okay,
Good afternoon. Respondent request 5.
let's do 4 and 1 and 4. Lev versus Italy USA is a submit. Coney Island Auto versus Parts Authority is a submit. Mariana Trading versus Amazon is a submit. First case on the calendar. People versus Bawa. You may proceed.
Good afternoon, Your Honors. May it please the court, Rashad Moore for Mr. Bawa. The Marijuana Regulation and Taxation Act, or MRTA, applied to Mr. Bawa's suppression hearing and required suppression of the evidence. The statutory text is clear. In any criminal proceeding, including proceedings pursuant to 71020 of the Criminal Procedure Law, the legislature is identifying suppression hearings, no finding or determination of reasonable cause to believe a crime has been committed shall be based on, among
So
other
even
things.
assuming you're correct in that argument, how do we reach that issue in light of the waiver?
So Mr. Bawa expressed confusion at the waiver. He told the court that it was going too fast, and the court didn't go back to ask what was too fast, what he didn't comprehend. Combining that with Mr. Bawa's inexperience with the criminal legal
Did
system,
he say he didn't comprehend, or he simply stated, you're going too
talking too
fast, and the court then slowed down?
the court didn't slow down, but it didn't go back to ask Mr. Bawa when did he start talking too fast and what part either confused him. Even
But
though
he didn't say I'm confused. He said you're talking too fast.
that's correct, but
So the confusion is what you're saying, not what he said.
that's correct, Your Honor. But the implication there is that he missed what was being said to
The
him.
implication.
That's correct, Your Honor.
Okay.
When you combine that with his inexperience with the legal system, plus he already signed the waiver beforehand, before the court had a colloquy
Is
with.
that, at least in the first department, we really haven't said that that's an issue, correct?
That's correct.
Second department may be a different rule.
That's correct, Your Honor. But when you combine all of these things under the totality of the
But did
circumstances,
the judge miss anything in his waiver of the right to appeal when he was speaking to the defendant?
so the court noted that ordinarily an individual would be able to argue on appeal through his lawyer various issues, but that through your lawyer language didn't appear again when the court noted that Mr. Bawa was still going to be able to raise issues on appeal. So he was, from the record, it's unclear Mr. Bawa understood that he was going to have an attorney on appeal. Moving back to the MRTA issue, the structure also makes clear that
No, and you see, we're focusing on the waiver because, speaking for myself, I don't necessarily disagree with your reading of the statute, right? The problem that we have is our case law says if you take a plea and you waive your right to appeal, you forfeit your right to have the suppression decision reviewed. So how do we get past that if we determine that there's a valid waiver here? Is there any way for us to get past that waiver to even address this issue on the merits?
if you believe it's valid, then there's no way to get through. However, the Court of Appeals has been pretty clear on this, that the totality of the record needs to demonstrate that Mr. Bawa here knowingly and intelligently and voluntarily waived his right to appeal, and the factors I listed earlier altogether doesn't demonstrate that it was a knowing, intelligent, and voluntary
Did
waiver.
the court, for example, explain to the defendant that the right to appeal is separate and distinct?
Yes, he did, Your Honor.
So it's really, so the only thing, what you're saying is that there was confusion because the judge was going too fast.
That's correct, Your Honor. And from
Any case law that supports that position that we can hang our hat on?
not any specific case law, Your Honor, but the problem here is that we don't know, from a cold record, we don't know when the court started talking too fast.
But we don't know that he was confused either, because he never said, Judge, I'm confused, you're going too fast.
No, Your Honor, but the implication is that when someone's talking too fast and you slow them down, it's because you missed something.
That's what you say is the implication. What did the defendant say on the record as he was waiving his right to appeal?
He followed normally. When the court asked him whether he understood, he said, yes, Your Honor.
And he said yes.
Yes, that's correct. But Mr. Barlo already felt bound to it. He'd signed the appeal waiver beforehand, before it was explained to him. Any sort of saying I understand here was mildly coercive because he already felt bound
Oh,
to
come
it.
on, coercive?
Mildly, Your Honor.
I seen coercive pleas. This is not a coercive plea.
Coercive is a short burst of words, but mildly.
Well, the court asked him, he had his lawyer next to him. You went over this appeal waiver document with your lawyer? Yes. And then the court went and explained to him what it was that he was waiving and what it was that survived. And at no time did he say, Judge, I don't understand what you're saying.
That's correct, Your Honor, but appeal waiver jurisprudence is difficult even for lawyers to parse. To imagine that an individual inexperienced with the criminal legal system accepting his first plea, who barely has a college education, working at getting his associates, and feeling bound by a waiver he had signed beforehand, knowing that this was a plea he was accepting here and today, and then being incarcerated, it's unlikely that Mr. Barlo was going to do anything to sort of quote-unquote rock the boat.
Okay.
And moving to the suppression issue,
You got 30 seconds, so make them count.
they can count. The court below said that it's unconstitutional to send a citizen to arrest, and I quote, so it's not a Terry situation. Under any circumstances, it can't be justified as a Terry situation, but then said that it's a protective pat-down. And in this court's jurisprudence, it said that for a pat-down, there must be a particularized reasonable suspicion that the suspect is armed and may be dangerous. And here there was no indicia of such, and that's why there was no exigency to support the search incident to arrest. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors. My name is Brian Wattoon for the respondent. I'll start with the appeal waiver, where we spent most of the time, and I'll give my adversary credit. He was very upfront about what the appeal waiver did and didn't say, and as Your Honors pointed
why
out,
do you believe the waiver is valid and that that's a knowing waiver? Why was it valid in this case?
why was it valid? Oh, as Your Honors indicated, the court hit all the relevant points to show that the defendant was
Well, you're talking
voluntarily.
very slowly, but I think the court was talking much faster.
I've been told many times that I talk very slowly. My wife gets particularly frustrated.
Well, what about that? I mean, that's the issue.
At each step of the colloquy, up to that point, the defendant responded appropriately, indicated that he understood what the court was saying. He conferred with his attorney, and the record reflects that he conferred with his attorney about the written appeal waiver. And it was only at that one point, after responding appropriately and following along, that he didn't indicate confusion, certainly not confusion about the proceedings that had taken place already, but that the court was speaking too fast. And in that one instance, the court said, sorry, I'll repeat myself. The court was very willing to accommodate defendant and acknowledge that perhaps at that one instance, it had gotten too fast. The court, saw defendant on that day, heard his answers, saw him interact with his counsel, heard him say twice that this is what he wanted to do, that he understood the appeal waiver, and the court, which was in the best position to assess the voluntariness of the waiver, found that the defendant had indeed waived his right to appeal voluntarily. As to the merits, the holding and the reasoning of Pastrana explicitly apply here, despite the footnote. The
It
reasoning
wasn't the same situation as here.
but the holding and the reasoning apply, are contingent on when the search occurred, not when the suppression hearing occurred. And to pin the effectiveness of the MRTA to when the suppression hearing
But the
occurred
issues of the
gives,
suppression are dealt with at the time of the suppression, not at the time of the stop. So I'm not so sure that Pastrana would apply as it did in Pastrana under this fact pattern, absent the waiver.
Right, well, of course, addressing the merits absent the waiver.
Right.
The Court of Appeals was clear that it was about the retroactive effect of the MRTA, regardless of whether it refers to a prospective judicial determination.
I think they were focused on what the intent of the legislature was. And if we are going to be bound by that, then it is very clear that the legislature intended that probable cause not be established on the basis that it was here. It would not be sufficient on this fact pattern under the statute today.
I think the critical distinction is the legislature was clear about that going forward once the MRTA became effective.
That has yet to be decided, counsel.
Respectfully, I do believe it was decided in
I
Pastrana.
don't agree.
Understood, but and the reasoning of Pastrana that referred to the effect on lawful police conduct at the time, and whether you should suppress lawfully obtained evidence would be purposeless in situations like that, because the sole purpose of the exclusionary rule is to deter future police misconduct. And if there was no misconduct in the first instance, then no deterrent effect is accomplished. Furthermore, you would have arbitrary results from defendant to defendant, because if you had a defendant who did the same thing on the same day, was subject to the same police search, they would get an opposite outcome if this court were to change the rule from Pastrana, depending on when their hearing occurred. And there's no way those two defendants should have completely different outcomes based on the arbitrary date of when the hearing occurred, rather than based on any police conduct, or rather than based on when the MRTA became effective. And another issue.
Policy arguments, but wouldn't we just look at what the intent of the legislature was? I mean, isn't that really the main focus?
If you want to look at the intent of the legislature, the Court of Appeals is also clear about that. It's right in the opinion. It says the
Counsel, you keep on, you pretend as though Pastrana was in the same context as this case, and it simply is not. So I understand why you are arguing Pastrana, but we are not on equal footing on the facts there. So I get it. You are making your argument, extending it to this fact pattern. But that's not what that case holds, because that wasn't the fact pattern in that case.
Respectfully, Your Honor, the Court of Appeals.
We know what respectfully means here, okay?
The Court of Appeals ruled not just the Court of Appeals ruled not just on the specific facts of Pastrana, but it's expressly
we don't have to
stated
debate this.
nothing in the text or legislative history.
I disagree with you completely in terms of what the legislature intended to do with this statute. But that's for another day.
Understood, Your Honor.
Thank you.
Thank you.
You may proceed.
So as this court notes, my adversary misreads Pastrana. The court was, in that case, talking about whether the first provision of the text, whether there was a suppression hearing where this situation was dealt at, and that was wrong. In that case, the first time this MRTA issue had been raised was on appeal, and the Court of Appeals was noting that an appeal is not a criminal procedure within the text of the statute. My adversary also talks about the deterrence effect of the exclusionary rule, but that's not the only portion of the exclusionary rule or the only purpose of the Fourth Amendment. It's about whether the court wants to legitimize discriminatory policing in this case, and that's essentially what we have here. The legislature sought to protect New Yorkers from how marijuana law was being applied in cases like this, and in doing so, it created a system that allowed courts to be the backstop, the due process backstop for individuals like Mr. Bawa and those similarly situated, and it doesn't create arbitrary results here. Anything after March 31st, if a suppression hearing happened after that date, March 31st, 2021 or 2 of the year, I believe, then it would be it should be suppressed. And it's a limited amount of individuals who have a search before the MRTA's passage and after. So it's a small number, and there's no arbitrary date. Everything is pinned to what the legislature did when it passed the MRTA. Thank you.
Thank you. Kane versus 42 West 65th Street. You may proceed.
Good afternoon, Your Honors. May it please the Court. Rose and Rose by Paul Coppy for the appellant, 42 West 65th LLC. The Division of Housing and Community Renewal a few years ago amended the Rent Stabilization Code to specifically provide that a challenge to a high rent vacancy deregulation brought more than 4 years after the deregulation would be time barred absent a colorable allegation showing of fraud. That salutary amendment to the Rent Stabilization Code really just gives effect to the 1997 Rent Regulatory Reform Act that allowed owners to dispose of records after 4 years. Notwithstanding all of that,
So
this case,
the complaint here is framed in fraud, correct?
in what year is
Framed
Kane?
by fraud, alleging that the landlord committed fraud. What's your position with respect to that? Is there a colorable basis of fraud based on the observations the tenant had when he came into the apartment in 2021? Is that sufficient?
In this case, it's not.
this case.
It's not remotely colorable.
Why?
The tenant alleged only the sum total of the tenant's allegations were. It does not appear that the renovations that were performed could have cost enough money to deregulate the apartment. That's in the context of an apartment that was severely fire damaged 15 years earlier and was then essentially gut renovated.
And did you document the payments?
We did, yes, they're all documented. The payments are all documented.
And they were submitted in evidence as a part of the hearing, right?
They were submitted in support of the summary judgment motion. They were really not credibly attacked in any way. The documents referenced the specific apartment. In fact, the fire was documented. The fire was severe enough to have been written up in the New York Times, and a number of firefighters were given merit citations for pulling somebody who was described as effectively being dead and brought back to life out of the fire. Again, the lease to the first deregulated tenant was produced. The DHCR registration from 2005 with a rent of $14.76, not too far from the deregulation threshold, was submitted on summary judgment. It was never challenged. It seems like not a close case to me, to be honest. The case was commenced really just purely on speculation. In opposition to summary judgment, the plaintiff said that it needed discovery, but didn't say what specific documents it expected to uncover in discovery, did not even annex its discovery demand to its opposition to summary judgment, and relied CPLR 3212F, on which they relied, says that in order to defeat a motion for summary judgment based on discovery either not having proceeded or being incomplete, it must appear to the court that facts exist that, in addition, are in the exclusive control of the party moving for summary judgment. But apart from that, it must appear that the facts actually exist. And I would submit to Your Honors that there is simply no basis to conclude that there's any reason to think that facts existed to defeat summary judgment. It's only about $5,700 worth of improvements that needed to be documented.
How much were that documented?
The documentation was about $23,000.
Thank you. Why don't we
Yeah, thank you.
see what the other side has to say?
May it please the court, for respondent, Heather Tacotin of the Price Law Firm. Good afternoon.
Good afternoon.
So I remind everyone here, though I'm sure your honors know, that we're standing here because we argued this very motion in front of a Supreme Court justice who found triable issues of material fact.
So let's look at the records. It's record pages 83 to 96. Documented records in terms of what the improvements are over $20,000. How do you address that?
So I can name a number of issues of triable fact right here before this court. Number one, they're arguing that there was a fire that decimated the building, and that was the reason for all the repairs. They don't explain if the tenant was displaced as a reason for the fire, which would...
They don't have to. That is not the issue.
They would...
That is not the issue. The issue is, did they do improvements? How much? Are they documented? Do we have canceled checks? Yes, 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 and yes. So, tell me, what relevant questions are there to defeat the evidence submitted on summary judgment?
Well, if there was a fire that displaced a tenant, judge, then the renovations would have been required.
That was 11, that happened 11 years at least before your client even moved into the building.
Right, but the
So that is, counsel, I understand, but that's not the issue.
Well,
that is not the issue.
I believe the issue is that they would have to prove if they were required to do the renovations or if they could take them as IAIs, Your Honor.
The apartment burned.
So, Judge, there's no proof of that. There's literally no evidence presented. And in fact, if you look at page 128
So
of
now
the
you're
record,
saying that in addition to the documentation that is normally required of a landlord, now if there is a fire that caused them to have to renovate, now they have to prove to you the fire too?
their very evidence shows that on page 128 that there were 6 tenants in residence at the time this alleged fire decimated the building that were still in residence after the fire occurred. Their rent roll demonstrates
So
that.
sometimes a fire happens in one apartment, and the only thing that is totally destroyed is that one apartment.
Correct, Judge. And that apartment,
So the fact
was
that
on the
other
3rd
people
floor.
live there is irrelevant.
My client lived on the 5th floor. The article they attached demonstrates that the fire took place on the 3rd floor. The apartment directly next to my client was occupied the entire time.
Smoke usually goes up.
That's correct, but the apartment next to my client's was occupied, so clearly they weren't destroyed. Someone was in residence. That's in their own paperwork. And additionally, they said that they couldn't get any documents from the prior owner, but the prior owner would have had the lease agreements that would show whether the tenant was in residence at the time the fire took place or whether she vacated of her own free will, which would lend questions to the vacancy increase they could take, as well as whether or not they were required to repair the apartment to restore a tenant to a rent-stabilized apartment. All of these are questions of fact. Additionally, Mitchell Rothkin is the one who submitted the affidavit in support of the summary judgment motion. Mitchell Rothkin can be called into question. He was disbarred by this very court, and he was imprisoned for being unethical and having a reputation of lying, Judge. So additionally, there's invoices that are marked up. We didn't have a chance to depose anyone to explain the markings, if they were written at the time, if they were written by Mitchell Rothkin, why they were written. They actually designate the apartment in handwriting. We have no idea whose that is. That's a triable issue of fact. This court here today isn't determining whether or not the apartment is in fact rent stabilized. They're determining if there's issues of triable fact, and we would argue that there are. We were never given a chance to dispute or deal with these invoices in any way, shape, or form because it was a summary judgment motion pre-discovery. So we would respectfully submit to the court that there are triable issues of fact and discovery should continue.
Okay, thank you.
Thank you.
You have 2 minutes.
I'll be brief.
Are the records you submitted, are they business records?
They are business
Have you
records.
established that?
They're sure, and yes, and it's in Mr. Rothkin's affidavit. It is true that Mr. Rothkin, some 25 years ago, was in fact disbarred. That does not disqualify him from submitting an affidavit and does not in itself invalidate anything that he said. Sure, these are all records that were made and kept in the regular course of the landlord's business. It was in the regular course of the landlord's business to make and keep records such as this. Documentation of apartment improvements really are classic business records. I want to talk briefly about it's actually an arrears report that my client obtained at the closing that recites 6 occupied apartments in the building, which were rent regulated. What that shows really is that there were rent-stabilized residents of the building at the time of the fire. Some of them probably had to temporarily relocate. Once their apartments were repaired, they were restored to possession and remained rent-stabilized. It doesn't call anything into question. If anything, it underlines, not my client, it was actually the previous owner, but appears to have done everything strictly by the book. This apartment was vacant and it was renovated. The suggestion that maybe it didn't qualify for deregulation because there was some coercion in getting the prior tenant to leave, that's just rank speculation. The notion that the canceled checks and the work orders and the invoices for appliances, all directed to this very specific apartment, are somehow tainted, that's also rank speculation. Thank you, Your Honor.
Thank you. Adcmin versus DHCR.
If it please the court, Arlene Boop, Alterman and Boop LLP for the appellant Matthew Adcmin. The underlying claim is rent overcharge in which the appellant has challenged DHCR's failure to award treble damages. I want to highlight only 3 facts from this record. First, the overcharges occurred in circumstances where it's clear that the intervener knew that the unit was rent stabilized. Aside from issues of confusion at the outset of its tenure as an owner, 3 years after that ownership began, the intervener owner recognized that it was rent stabilized as indicated by its filing the unit with the DHCR in January of 2010. So whatever confusion was obviously resolved at that time. Secondly, it was only a year after this filing that the first of the 2 illegal 15 and then 25% rent increases incurred. So it occurred way down the line of the facts. And third, there is not even a suggestion of this in this record of a reason or an excuse why these overcharges were imposed.
So in this case, the overcharges were repaid, correct, voluntarily?
Your Honor,
Were the overcharges repaid voluntarily by the owner?
Your Honor, the overcharge plus interest, it was tendered to appellant. It appeared that they were asking that that be the end of his claim. It was rejected, but
I understand that, but
that was the basis.
I'm asking you, what impact does that have, especially in light of DHCR policy statement 89-2?
Your Honor, the impact is we're challenging that policy. We're challenging it in 2 ways. One, as being the sole determinative factor, because the policy really changes the burden of proof, which should be under the statute, a preponderance of evidence on the owner. And secondly, it creates a class of willful overcharges that are excused after the fact. I mean, willful has a plain English meaning. It's intentional. And there's nothing in the statute, and the reference point for intentional is the time the action is taken. It's not something that occurs here, actually about 5 years later, but after the overcharges were imposed.
So it has no impact with regard to willfulness? There's no impact as with regard to willfulness? It is your position that it does not affect the willfulness? That it's willful and that's it?
That's willful and that's it. And there's nothing in the statute which would authorize, again, excusing something that is willful by the facts several years after the fact. The other point of our challenge has to do with a standard that all parties seem to agree that it's not just the policy, but a consideration of all the factors. But here, in the factors I highlighted, at the outset, were not anywhere in the record or in the agency's determination. And in fact, when the court below indicated that the agency must have considered all the factors, it was simply wrong. It was wrong because the factors it cited were the factors the agency cited with reference to whether there was sufficient evidence of fraud to require that extended look-back period. And in this Article 78, appellant did not challenge that prong of the agency's determination. You know, it was also wrong because, again, these factors that were cited occurred at the outset of the appellant's occupancy, and it happened like the month later, the intervener's ownership of the premises, not 4 years later when the overcharges actually incurred. So, you know, the other issue we have is the precedent issue. There's not been any appellate decision cited that would indicate that even though where there's a direct challenge to the policy, the cases all cited, minus the one Supreme Court case I've discussed in my brief from Kings County, they've all been cases where the court said the failure to even reach the minimum standard of this policy means it's still a willful overcharge, not the converse. And the logic doesn't create those being precedents for this. I would note the one case in Supreme Court cites as one of its factors, actually two things. One, that the legislature had not chosen to repudiate that policy. Well, obviously, with the passage of the Housing Stability Tenant Protection Act, it has so repudiated. The court in that case also said, well, there's a logic to two classes of owners, some who return the overcharge and some not. And that may be logical, but it's not a logic that finds any support in either the statute or the policy of the statute, one of which the main points is to avoid subterfuge or avoid evasion of the fair rent increase provisions of that statute. And the policy really incentivizes it. For an owner, overcharge as much as you want. If you get caught, you simply return it with the interest.
Thank you.
May it please the court, my name is Lauren Lipnick, representing respondent, New York State Division of Housing and Community Renewal. First, the standard for review for the appellant to prove that DHCR acted arbitrarily and capriciously in finding that the owner's overcharge lacked willfulness and was not required to pay treble damages.
Well, let's talk about this willfulness, because they knew that this was a rent-stabilized apartment.
Well,
so I don't understand how they can argue that this wasn't willful, that this was not an absolute willful overcharge.
Well, the lower court found that...
I know what the lower court found. I'm telling you what I think. Okay. So why should we not say that this tenant is entitled to treble damages when the landlord here clearly charged over the amount he was entitled to, knowing he was charging over the amount he was entitled to?
Well,
that's as willful as it gets.
Well, the prior owner rented the apartment to the tenant, who's a relative of the prior owner.
Yes, we know this.
Yes, and he gave him a non-rent regulated lease. Also.
But then a few years later, wasn't the apartment registered as stabilized?
They did register it as stabilized.
So they registered as stabilized, and then there were charges that were beyond the appropriate rent, correct?
Right, and that was
so you agree with those facts. Owner knows that the apartment is regulated, and then charges more.
Well,
so in that instance, how has the owner overcome the presumption of willfulness?
Well, DHCR does look to policy statement 89-2 as a factor in addition.
Is it the only factor, or as your adversary says, it's one factor in totality of the circumstances?
Yeah, they looked at the totality of the circumstances. It was that fact of the non-regulated lease. It was also the fact that there was no evidence of raising the rent anywhere close to the deregulation threshold. That was also evidence.
That's not the nature of the case. It's an overcharge case, right?
Right.
And you admit that there was an overcharge, that the landlord
there was an
intentionally,
overcharge.
that the landlord intentionally charged more than could have been charged. And then when there was a complaint, presumably the money there was an attempt to return the money, and you say that vitiates the willfulness, in essence.
Yeah, it is DHR's position that in addition to the refund, that because of the facts, that they were credibly confused because of
They were not confused. They registered the apartment as a rent-stabilized unit, and then they overcharged. There's no confusion there. They intentionally overcharged. So why should this tenant not be entitled to treble damages? In keeping with your adversary's last argument, this policy basically gives an open door to landlords to overcharge every tenant they feel like it, in the hopes that they won't notice, that they won't fight back, and that they can get away with it. Because your client only paid back when there was a complaint.
Yeah,
right?
I represent DHCR, just.
Okay.
But,
Never mind, I'm sorry.
but I will note that just this policy that was issued in 1989, and for 30 years, it was the policy until HISPA eliminated the safe harbor. DHCR does take a large amount of...
But there are no, really, for DHCR to have made this decision in this case, there is zero evidence in the record. And if there is, please tell me where I have missed it. But I see nothing in this record that tells me anything other than this landlord intentionally overcharged and only was willing to pay it back when they were caught. That's what this record shows. So I'm trying to understand why DHCR says, oh, by policy, we're just going to give landlords a pass. What? This policy opens the door.
Well, this policy has been followed for...
That's wonderful. But we see how it was abused here. So I'm trying to understand why DHCR on these facts would reach this decision.
Based on the totality of the evidence.
Okay, so let's just talk about the totality of the evidence. Back in 2000, when the building was purchased, I mean, I know there's some concern it was given to a family member, not regulated lease, but clearly, didn't the rent rolls, the contracts, didn't everything at the time of purchase indicate that this apartment was subject to a rent stabilization?
Well,
Is that a fair?
It was supposed, when the prior owner signed the contract with the current owner, it was put out that it was a vacant apartment. There was an indication of rent stabilization. But
Okay, so you agree that it was rent stabilized even back in 2007, and maybe there was confusion because of the nature of the lease given, but 2010, the owner registers it as rent stabilized, and then after that, there are overcharges. I just don't understand how the owner has overcome the burden to establish, overcome the burden of presumption of willfulness.
Mostly because the Bolus case talks about how there's basis for treating owners that refund right away differently than ones that wait until then there's been a decision.
Well, in this case, was it a voluntary, or did
It was voluntarily.
Did the tenant have to do something? Did the tenant make a complaint?
Well, yes, they may assume.
Then how is it a voluntary?
That's not
how is it
voluntary.
voluntary under
That,
those circumstances?
that is the policy, that as soon as the complaint, if they refund the money with interest before the time to answer, that is, and they've done it in good faith, that is how, the policy that was until.
How is that good faith? I don't understand this finding of good faith here. He doesn't, look, he knows, they know, because they registered the apartment as rent stabilized. They did that. So whatever confusion, and it wasn't confusion, you weren't supposed to occupy the apartment and you did with a relative. I get it. But it doesn't matter because that apartment was rent stabilized anyway. Whoever went into that apartment, it would have been a rent stabilized apartment.
There was also indication in the rent roll that there was a market rent written in there also. So there was some.
So fine, so confusion between 2000 and 2010, that's 3 years. We're talking about stuff that happened post that, correct?
Yeah, I can't speak to why the owner registered it. But DHCR determined based on all the factors because of the lease and because they weren't increasing it to that degree to try to, in certain situations where people try to get it out of rent stabilization if they know, that this was, especially because of the refund, that was why they determined.
All right, thank you.
Thank you.
And my questions weren't personal, you know that, right? Okay. Segal versus Danella Construction.
May it please the court, my name is Matthew Lerner, and I represent the appellant Danella Construction of New York Incorporated. I first want to emphasize the central issue in this case, which is causation. The plaintiffs are alleging that a pothole that was formed 3 to 4 feet away from an excavation that my client worked on was a continuous, dangerous condition and try to tie it to our work. There's no competent evidence demonstrating so, and the Supreme Court actually denied their motion for summary judgment based on that fact. They didn't make a prima facie.
How did you make out your prima facie?
Yeah.
That's what I'm interested in learning.
It's interesting because the Supreme Court basically jumped the movement's burden and went to our burden, started talking about our burden. We met our burden on our cross motion by demonstrating a couple of things. Our foreman, Antonio Diaz, testified, and he looked at the photographs, there were a number of photographs, and said, the excavation is separate and distinct, and that the pothole had—
That pothole is right on the corner of one of the steel plates. So it is absolutely right up on top of where the excavation plates are. So to attempt, once I saw, I'm reading the papers, and when I looked at the photographs, I was like, what are they talking about? This is right there. So any argument that it's over there, far away, you can dispense with that because we have the pictures, and the pictures speak for themselves. That pothole is right underneath one of those plates. Right underneath.
That's the issue. One of the issues in the case is that we're looking at the photos, and for example, the attorney is interpreting the photos, and that's the troubling part of this case, is that they didn't meet their burden in response to our motion. An attorney is interpreting.
But we don't even get to that if you didn't meet your burden in the first instance, and I still am not convinced, based on my colleague's question, of how you met your burden, given the fact that the pothole is right up on next to the plate.
But our expert, Tracy, they explained that that's not the case. They explained that it was covering.
Are you telling me my eyes are lying from what I see? I don't.
I'm not saying that you're lying. I see what's going on too. It's cold patch. That's what Tracy and Antonio Diaz were talking about. It's up against I understand the confusion. It's up against the plates. Antonio Diaz is saying it's 3 and 4 feet away from it.
It is right on the plate. Right on the plate, okay? So you can say and argue, and it doesn't matter what your expert says. The picture speaks for itself. What it looks to me is somehow when they excavated, they didn't shore up underneath this point because that shouldn't have collapsed.
Your Honor, we talked.
Okay.
There was evidence regarding shoring. In fact, regulation for New York City dealing with excavations, our excavation was only 4.5 feet deep. The regulation
That could
requires,
bury some people.
sure,
Mm-hmm.
but
That's a big hole.
the point is, regarding shoring, is that it's only required if the depth is 5 feet. We did shore the excavation. We had braces. It wasn't required to have braces. We had braces. What our expert and what our witnesses with firsthand knowledge stated was that was a separate pothole formed away from the excavation. That's how we met our burden. In opposition, all that the attorney did was he basically inspected the photographs. Now, you've said to me the photograph speaks for itself. You have to reject a witness who has firsthand knowledge. Also, we had the project supervisor, John Masery, who took that photo 3 days beforehand. There's a photo in the record, I believe it's on 784, that shows that that excavation was covered with metal plates as we were required to do. It was like that for approximately 18 days. And that's where our expert comes in and says, this situation was static for 18 days. And it wouldn't be, if there was an issue regarding the shoring, this collapse would have happened well before then. That's what our expert testifies to, and that's how we met our burden.
Okay.
May it please the court. My name is Judah Cohen, and I represent the plaintiff. I want to pivot immediately to what Your Honor, Judge Manzanet, had said earlier concerning the photograph located at page 305 on the record and 306, and the testimony of their four men on the job the day after the accident and who was there excavating that actual area 2 weeks before the accident. On page 488 of the record, he specifically admitted that the plates extended and covered the collapsed portion. Also, Danella, who performed the excavation, they also performed the bracing. And he admitted at page 491 that the bracing broke that we put in. It has been my position and the plaintiff's position on the lower court. It defies credulity to look at these pictures and to have some expert or somebody to come along after the fact and maintain that this somehow occurred 3 to 4 feet away. It did not. It's part and parcel of the actual excavation, and their witness even admits to that. The fact that they have an expert affidavit 7 years later who never examined the site, who speculates and gives an expert opinion concerning what may have occurred without any testing whatsoever should not be countenanced, and it shouldn't have been countenanced by the lower court as to create some question of fact. That's one of the reasons why it was our original position on our motion for summary judgment that it is the plaintiff that should be entitled to summary judgment. But even if that is not the case, and somehow this court believes that all of this somehow creates a question in fact, which we do not believe that that's the case, then it is our contention then that all of this combined is really one big material triable question of fact that should really be submitted to the jury. Thank you for your consideration.
Thank you.
Just briefly, Your Honors, I want to speak to the fact that the expert didn't visit the site. I think that's an irrelevant issue.
Our case law doesn't require that, does it?
I don't believe so. And even if the case law did require
Doesn't the
it.
expert's testimony or opinion testimony have to be based on the record? And it seems to me, at least when I look at the pictures, the pothole is there. So I take with a grain of salt the statements about where the pothole is, correct? I mean, isn't that a fair point?
It is a fair point, but he relies on Antonio Diaz and John Masery. And he interprets the pictures based on what their firsthand knowledge
Did he look at the
states.
pictures himself and decide where the pothole was?
Well, he might have. I don't know. He references Diaz and Masri. And my point regarding not visiting the site is the importance of the expert witness affidavit is I mentioned it on my main argument, that the fact that this condition was static for 18 days without anything happening, and then 3 days later, there's a collapse, demonstrates to this expert, and that's how we met our burden of proof, that it wasn't caused by Danella's negligence. There are many different reasons why potholes in New York are created.
Was there an explanation by the expert as to what caused the pothole? I don't think so.
No, he didn't. He did not.
And would that be required?
I don't believe so.
And neither did Diaz state or explain how this hole was created.
He didn't. He said he had a theory.
He had a theory, but he didn't say that it was.
He outright said no. I'm sorry, Your Honor. I didn't mean to talk over you.
Thank
you very much.
If I may, Your Honors, for just one point concerning the defendant's expert, at page 678, paragraph 4, he did not review Mazzari. He only reviewed photographs, which we don't know which photographs per se, because it's said in the air, photographs. And then he says, the deposition testimony of Mr. Antonio Diaz only. He did not review Mazzari's affidavit. He did not review the affidavit that Diaz submitted afterwards, and he didn't review the plaintiff's deposition testimony either. Thank you again.
Thank you. All right, let's see Isaac here. I'm going to skip the next case until I see the counsel who we're waiting for. People versus Jean-Guillain Beltri. You may proceed.
Good afternoon, and may it please the court. Alexandra Ricks from the Office of the Appellate Defender for Jean-Guillain Beltri. I'm going to start by addressing the Factor 8 points, which should not have been awarded, and without which Mr. Guillen would have been properly scored only 65 points, making him a presumptive level 1. The prosecution did not prove by clear and convincing evidence that Mr. Guillen was 20 years old when this conduct began.
Counsel, let's say that if we were to agree with you that that was not proven by clear and convincing evidence and that Mr. Guillen Beltri is a level 1, was the court somehow precluded because of that from departing upward? Once the court found that certain crimes that he committed were not captured by the risk assessment instrument, was the court precluded somehow, because he was now a level 1, from departing upwards to a level 3?
While such a departure may be allowed, in this case, the court was assessing the departure based on a presumptive level 2. And so if the court is to agree that the Factor 8 points should not have been awarded and that his correct presumptive level is a level 1, well, we would urge that you make him a level 1 now because the departure was inappropriate.
Why is it an abuse of discretion, even if it was a level 1, for an upward mod up to a level 3, based on the horrific circumstances of this case?
Well, Your Honor, the court below was not considering whether a departure from a level 1 to a level 3 was
That's fine. Please answer his question.
Yes, Your
I
Honor.
know you want to keep on going back to if he's presumptive 1, etc. Our question is very clear. Doesn't this record support, even if we were to agree that he should have been a level 1, why would this court not have been entitled to upwardly depart to a level 3 for the horrific circumstances of this case?
Your Honors, just to be clear, we do not at all mean to minimize the harm to the complainant or the seriousness of my client's conduct. But SORA is not a...
I really, I'm trying.
Yes, Your Honor, I can be more direct.
Okay, please.
The upward departure on the basis of the continuing course of conduct was inappropriate because continuing course of conduct is already captured by fact.
No, it wasn't captured
To this extent?
by a long shot.
Court,
He rapes his girlfriend's daughter for years, impregnates her not once but twice, having this 13-year-old have his child, and then again at 15, while he rapes her repeatedly, night after night, for years. So, again, based on that fact pattern, why would the court have been wrong in upwardly departing to a level 3 for someone who engaged in this kind of conduct?
because, Your Honor, the Court of Appeals is very clear that for an aggravator to be validly considered, it has to be both not considered by the RAI and bear on an individual's risk of future sexual recidivism or dangerousness. And none of the aggravators that were considered by the court below meet both of those requirements. The continuing course of conduct was already captured, and the harms to the complainant as well as the details
How
of
was the harm to this child captured here by multiple rapes, and now she has 2 children from that? What part of the RI captures that?
Her children are both the brother or sister to an aunt and uncle.
Absolutely.
Okay.
And I'm not at all here to minimize that. I understand that
And in her victim statement, she said, he stole my childhood.
Yes.
So tell me where in the RAI that got captured. Tell me where. Which point?
It's not captured by the RAI, but it
Okay.
also has to, there's a second prong, and it also has to, there has to be some demonstrated causal link between the circumstance being considered as an aggravator and the future risk of sexual
there's a
So what is
question
the
about-
future?
Yeah.
When he gets with another woman that has a teenage daughter?
We need to consider the fact that he has been punished, and we're not here to punish him again. He served 8 years in prison. He participated in SOCTP, and we need to evaluate the future risk looking
Yes,
forward,
and he
considering
continues to say, we were in love.
With an 11-year-old. You
Your Hon-
started.
And she came on to him.
Your Honors,
He
I
said
would
it.
just note that my client's acceptance of responsibility was not contested below. The board agreed. He accepted his plea, and he accepted a plea. He accepted responsibility.
Accepting a plea and participating in a program that you know is going to help you get out doesn't necessarily mean I have accepted responsibility. When he is telling people, we were in love.
And every time she looks at her children, she's going to be reminded that she was raped 100 times.
Yes, Your Honors, we would just ask that you look closely at the framework set out, that it has to be both not accounted for and have a demonstrated risk of harm. And I'll continue on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. Amir Kedmati for the respondent. Your Honor.
How did you prove he was 20? So that point assessment was correct. Why? How did you prove that?
Your Honor, the victim testified before the grand jury, and she said that the first time that she was penetrated by this defendant occurred sometime between Christmas of 2004 and of July of 2005.
Now, his birthday was in April.
Was in April, that's correct.
So that is one of the, and he would have been 20 in April?
He would have turned 21 in April, correct.
So how do we know that this happened before his 21st birthday?
Your Honor, first I'll remind the court that the standard of proof is clear and convincing evidence. And secondly, I'll say that the victim, she gave this testimony about 10 years after the fact, a little bit more. So the reason why she remembered that window of time, especially the end mark, the July reference point, was because she said a couple of months, a few months prior to that, was the first time she had her first period. So that takes us back to somewhere around April.
And she used the word a couple of months before. She didn't
Correct.
say, she didn't give a specific month.
That is correct. She
So
said,
we don't know what a couple of months is.
but from July to April, basically, we believe that that basically suggests that the conduct occurred somewhere the conduct began somewhere closer to at least the halfway mark or like the earlier point.
But it's not clear and convincing that that is the case. It could have been in June, it could have been in May, perhaps in April, you see?
But when she said a couple of months, I still think because from April to June, July is.
When someone says a couple of months, what do they usually mean?
I would say anywhere from 2 to 4 months.
Not 2 months?
I'm so sorry?
Doesn't it mean 2 months generally in sort of verbiage?
Well, there's also another factor, Your Honor. The first time that this child was actually subjected to sexual abuse occurred even before that, because the victim testified that
The touching, you're talking
the touching. That's correct, Your Honor.
But let's assume that there is some ambiguity as to the age of the defendant. Even if he were a level 1, how do you respond to your adversary's position that, in essence, that Supreme Court abused its discretion to grant an upward modification to 3?
Your Honor, if there is ever a case that captures how the risk assessment instrument can fall woefully short of capturing the nuances of a case, it's this case. There is an epitome of aggravating factors that demonstrate both the likelihood of reoffense as well as the grave harm that would be caused should the defendant reoffend. And so I disagree with my adversary's contention that the Gelati factors are not met under this analysis. And I'll just very briefly address a couple of the aggravating factors. As Your Honor has pointed out, the length of time, first of all, is not captured under factor 4. But all of these issues from the duration of time, which we're talking about hundreds of acts of rape occurring, let's not forget, this defendant he was the son of the superintendent where the victim and her family had just moved in. So his family was present in that building when this conduct started. That didn't stop him. Hundreds of acts of rape in the presence of other children, and later his own daughter that he shared with the victim's mother, who slept in the same bedroom as the victim. So night after night, he would sneak out of his girlfriend's bedroom, go into another bedroom where multiple children are sleeping.
Rape her daughter.
And rape her daughter again and again.
Didn't the court state that?
Yes, Your Honor.
He state this offense may not capture the entirety of everything that has occurred over the span of time because we have recurring rapes?
That's correct, Your Honor. And we believe that these are all indicative of likelihood of reoffense because this defendant, just could not get his hands off of this child until he was actually evicted by the mother for unrelated reasons. So that addresses the likelihood of reoffense issue.
And he also had engaged in various acts of manipulation to prevent her from telling.
That is correct, Your Honor. He was extremely deceptive. First, we believe that he engaged in a scheme to enter this household to get access to this child, but thereafter, we are talking about not just 2 pregnancies. These pregnancies culminated in births, and that didn't stop this defendant. There were multiple incidents where the victim's brother walked into the bedroom while the defendant was raping her. That didn't stop him. There was another occasion where his own daughter had a therapist visiting their home, and defendant made the therapist wait until he finishes raping this child. As far as the harm that would be inflicted if this person reoffends, it's really difficult or perhaps impossible to capture in words, as Your Honor has alluded to it, how much pain this defendant has caused so many different parties involved. That child, her child, this is not just about raping a prepubescent child. This is about destroying a person's life. Not just hers. This defendant completely alienated her relationship with her mother. When she was testifying before the grand jury, she was homeless. Defendant completely destroyed this child's relationship with her brothers and her siblings who were children themselves.
The mother felt that this child had stolen her boyfriend.
Exactly. And so last but not least, as to the harm factors, I'll just say that basically everyone involved in this case was severely hard. And if this defendant is not on the highest level of supervision, we believe that the risk of harm to the community is too high, and he should be assessed the highest level of supervision as possible with the highest level of community notification for that.
Thank you.
Thank you, Your Honors.
You have 1 minute.
If I could just really briefly speak to remedy. If Your Honors agree that the factor 8 points were erroneously assessed, but does not agree that the upward departure was incorrect, the correct remedy here is a remand to the lower court.
We don't have to remand if we have enough on the record.
The
We
court,
can make our own assessment, counsel.
this is a sequential assessment, and the court below didn't have the opportunity to assess whether an upward departure was right.
But he did say it, he stated it on the record. My colleague read it a few minutes ago, what the court said. The reason why it felt that this case, that this incident was not captured by the risk assessment instrument, and why it deserved a high risk level.
But the Court of Appeals recently, in the case People versus Weber, made clear that a SORA assessment is a sequential exercise that requires making the departure decision from the correct presumptive level. And if his presumptive level was not a 2 but a 1, the court below should be given the opportunity to make that assessment.
Thank you. Are the parties here on Sullivan versus Uber? Yes, Your Honor. Okay, we will hear you next. You may proceed.
Good afternoon, Your Honors. Jacob Tabor of Perkins Coie for Appellant Uber. In our view, the most critical factor in this litigation conduct waiver analysis is the presence of prejudice. And the court below did not find any prejudice. Plaintiff did not argue prejudice. And this court found in Universal, and it's also in Cusimano, that prejudice is an essential element. The purely defensive litigation conduct.
Your clients, Uber Technologies, has placed into their agreements a arbitration provision, correct?
Yes, Your Honor.
Because they want any litigation, any claims that may come up to be resolved in arbitration, correct?
Most claims, Your Honor. There are carve-outs for, I believe, sexual assault and certain other kinds of claims that are in court.
But generally, they want any litigation with their Uber drivers or anyone that utilizes their services to arbitrate outside of those exceptions, right? That's why you put that provision in the agreement, correct?
There are separate agreements with drivers who use the driver app and with riders who use the rider app, but as I understand it, both agreements have an arbitration clause. They're not identical arbitration clauses.
So the answer to my question is yes.
Yes,
Uber has, this can go easy or this can go hard, so you decide, okay? All right, so Uber has placed arbitration provisions inside their agreements because they want to arbitrate, right? And arbitration has specific rules and a way to play in arbitration, right? And one of those rules is you don't get normal discovery the way you do in a civil lawsuit, right? You have to make an application to the arbitrator if you want to proceed with some discovery before the proceedings, and they can consider whether this is that exceptional case that they should allow you. Isn't that generally how it works?
The scope of discovery available in arbitration will vary by the arbitral forum and the rules therein, as well as by the state in which the arbitration is proceeding, or if it's proceeding.
So let's talk about where we are, because you're not, you want to play this game, but okay. So arbitration doesn't normally give discovery in New York, right? Let's narrow it since we're here.
Plaintiff has asserted in her brief.
No. I'm asking you questions about arbitration because that is the mode of resolving disputes that your client chose. Correct?
Yes, Your Honor. Respectfully, I believe that this arbitration would proceed under the FAA, which does permit.
Good, so they could have gone to the FAA for their discovery. Instead, your client files a request for judicial intervention
Yes, Your Honor. Both Uber
so that
and
they could get discovery, which if they wanted, they should have gotten in arbitration.
both Uber and plaintiff requested.
No, I'm talking about Uber because plaintiff filed a lawsuit. And through their lawsuit, they would be able to get discovery if permitted to go forward. So my focus, God bless you, my focus is on Uber.
Yes,
Because Uber wanted arbitration. And then Uber files a request for judicial intervention to get police reports, right?
Yes, Your Honor.
Okay, now, I don't know, FOIL requests would have gotten them those police reports too. They didn't have to file a request for judicial intervention in contravention of their stated intent that they want to arbitrate cases and claims.
It is my understanding, and my client litigates a lot of these kinds of actions in New York, that the only way to obtain the police records, which all parties have agreed are critical evidence that plaintiff also requested and that plaintiff cannot possibly claim to have been prejudiced by receiving, the only way to obtain those, whether you're in litigation.
Plaintiff, like I said, plaintiff would have gotten them anyway because they filed a lawsuit.
Right, and so therefore there's no prejudice to plaintiff, and prejudice is an essential showing to find that Uber has waived its contractual right to arbitrate. And there has been no prejudice through obtaining these police records.
Is that counsel you answered? You filed cross claims for indemnity and contribution against non-Uber drivers. You filed an RJI. You got discovery. You didn't waive?
No, ma'am, respectfully. No, Your Honor. The cross claims first are, I think, very analogous to filing an affirmative defense and an answer. It is something that you do at the outset of a case, because if you don't do it in your answer, you waive it. And when you file that answer, you don't know yet if your motion to compel arbitration is going to be granted or not. So you preserve it in case it comes up later.
Except
That's
you
all the
never
cross
moved to
claim is.
compel.
No.
Instead, you stayed in the civil court, and I'm gonna play here for a while and get as much discovery as I can, and then I'm gonna ask for arbitration.
We did not take any discovery from plaintiff. We did not request any discovery. The only discovery that was taken was receiving the police records from the NYPD, which would have happened anyway. And the only reason we
So
didn't
then
file
why,
a motion-
if it would have happened anyway, then why did you file an RJI? And
Why not move to compel?
request the assistance of the court?
Because those were documents that were necessary for the cross claims, which were non-arbitrable and which were going to proceed regardless, as well as for, they would have been necessary in the arbitration. We could have waited and done it later, and that would have been less efficient for everyone. Plaintiff agreed that those were essential documents that she requested also. The so ordered subpoena was issued, as it always is. This is a boilerplate that occurs, as I understand it, in virtually every traffic accident where there's been a police investigation, where there's been an injury. And so we don't view that as having prejudice. If I may just address
You'll have
not
time
moving.
on rebuttal. Your clock is on.
Good afternoon, Your Honors. Jillian Rosen for the petitioner respondent. First, I just want to apologize for any confusion, us assuming that this would be submitted based on the letter about settlement. So I just apologize.
Just for the record, the courthouse closes at 5 o'clock, and we didn't receive communication until later than that, right?
Sure.
So there's no way for the court to have communicated to all of you last night.
No worries.
But you all understand that we don't start reading for the appeal the day before, okay? So we don't appreciate this kind of last minute, oh, can we adjourn? And oh, I don't have a written piece of paper saying that this case is resolved. You know how many cases I have on my calendar that people say, oh, we've resolved it, and then it resurfaces? So no, it's resolved. I want to see a piece of paper saying that, okay?
Yeah,
That's
so-
why I insisted that you come.
Sure, no worries, and my apologies for that, that it
So
was
you
sent
may
to the court
proceed.
after court
So
hours.
your adversary's, I guess, strongest point, maybe, is lack of prejudice. So could you address that, please?
Sure. I mean, I think that the litmus test isn't whether we would have gotten it through discovery on our own in the Supreme Court action. I think the litmus test is, did you avail yourself in the Supreme Court of the discovery and avail yourself of the forum? And our position on prejudice is that they charted their course and we engaged in discovery, and there were costs that were incurred, and that's one level of discovery.
Is prejudice a factor in determining whether or not, in this case, Uber's conduct, taken as a whole, was inconsistent with its right to arbitrate?
I think that it is a big factor in waiver. Prejudice is a factor in waiver. It is. But I think that we've met it.
Prejudice? So what's
the prejudice is having engaged in discovery in the Supreme King's action to the extent that we did with compliance.
But the Uber says only discovery requested was for the parties not subject to the arbitration. Are they correct about that?
No, because it's intertwined. It's one it's the indemnity and contribution obviously flows from the accident. I understand that that doesn't come to fruition until there's a payment or there's an allegation of liability asserted against Uber, but it's not separable, and you can't separate it. So in the event, because it's indivisible, it's our position that we were prejudiced to the extent that we had to, if they wanted to go to arbitration, that would be one course. Instead, we litigated the case in Supreme King's. There was compliance conference, preliminary conference, there was exchange of discovery. They made it an affirmative motion. I don't have to go through what you all did with my adversary, but this is litigation conduct waiver, and it has been documented to be, to the extent that they charted their course and we proceeded with the case, that we were prejudiced to that extent. In addition, Your Honor, that as you know, there are different standards. So under the arbitration, it's 3102, which requires the discovery to be extraordinary circumstances, as opposed to 3101 in Supreme King's for material and necessary under Allen against Cromwell. So in that regard, they fashioned their defense based on the case in Supreme King's. We proceeded with our prosecution of the case in Supreme King's. We're going along, and 6 months later, they write a letter saying, no, we've gotten all this, but on afterthought, we need to arbitrate. That's we think is a palpable prejudice under Cusimano.
So the first time that they served you with notice to compel arbitration was 6 months later?
It was, if you go from the answer, it's 5 months, it's March to August, because they answered, asserted their affirmative defense of arbitration, which we understand an answer alone isn't enough to waive. That's in conjunction with the other things. If you take it from the summons and complaint, which is why I say that's actually 8 months, is because what they could have done, which is recommended under the CPLR and the commentaries, is to either do a pre-answer motion to compel, a pre-answer motion to stay under 7302A. I'm not sure if I'm sorry, 7503A and B. And in that regard, if you look at it from the summons and complaint, it's actually 8 months. But if you want to look at it from when they actually affirmatively did something, it's 5 months.
So they waited until they got what they wanted in the courts, and then they...
Correct. In fact, they filed an RJI, moved for that police information 3 months before they then served a letter saying, you served a complaint, but we're doing an arbitration.
What about plaintiff's defendant's argument that they never asked for any discovery from plaintiff?
I mean, the cases, to be honest with you, they do go both ways. Sometimes they say that requesting it versus answering it doesn't establish the waiver. I mean, I think in this case, their position is we had no choice. The court ordered it while it was pending before Judge Kotler to decide the motions. We were ordered to do discovery. Our position on that is, I think it puts the horse before the cart. And if they had done what they could have, it's not mandated, but what they could have done in all fairness to level the playing field and have sent that motion done a motion to compel or to stay, either with the answer, pre-answer, or shortly after the answer, not 5 months, then the discovery issue wouldn't be in the position, posture that it was at the time, where they're saying, oh, well, we didn't ask for it, we were just forced by the court. We didn't want to violate a court order.
But the CPLR does not require that they do that. The CPLR is silent on that point.
The CPLR is silent on that, but the CPLR the whole point of arbitration, I would just say the point of arbitration is for swift adjudication, and our position is the case law that has evolved has been to is the recommendation is to do it sooner than later, as soon as you know that there's a case that's arbitrable, and that they knew that as of January 12th, 2022, and they didn't do anything until March, and then they didn't even do anything with respect to asking about arbitration until August of 2022. So under those circumstances, our position is litigation conduct waiver applies, and I'll rely on my brief to the extent. Thank you very much for hearing us today.
Thank you.
Just a few points in response, if I may. First, I believe Your Honor said that Uber did not move to compel arbitration. That's because when one files a notice of intention to arbitrate under 7503C, the other party has 20 days to move to stay. And so a motion to stay was filed before a motion to compel. That's just what 7503C contemplates. Second,
But counsel, I guess the point is you assert arbitration in your answer. You get all the discovery you need, and then you say, oh, by the way, we're done. We're going to go to arbitration. Doesn't that suggest that there is prejudice there?
Again, I have a hard time seeing how plaintiff was prejudiced by receipt of the same police file that everyone in this case needed, agreed was critical.
You lull the plaintiff into believing that they have to, that they're litigating the case in court, getting discovery, and then you change your mind.
I believe the Sherrill case in the Court of Appeals is clear that when we asserted the affirmative defense of the intention to arbitrate in our answer in March, that put plaintiff clearly on notice. I don't think we took any actions inconsistent with that intention to arbitrate until we served the notice of intention to arbitrate.
Okay, thank you. We're out of time.
Thank you, Your Honor.
Thank you. People versus Anthony Grant.
Good afternoon, Your Honors.
Good afternoon.
Mr. Gant asks that this court reverse the lower court's ruling.
Is it Gant, not Grant?
So, Your Honor, it's noted in our footnote in our principal brief that the appeals paperwork refers to him as Grant.
Okay, so it's Gant.
But it's his
all right,
legal name is
I'll
Gant.
fix it in the, so, got it. All right, I'll
you.
fix it. All right, you go ahead.
Your Honor, Mr. Gant asks that this court reverse the lower court's ruling as to the suppression of physical evidence, by which the court summarily denied both suppression of the physical evidence or in the alternative Mapp Dunaway hearings. Mr. Gant asks that this court hold this appeal in abeyance and remand for Mapp Dunaway hearings. The court may do so because the waiver of appeal in this case is invalid and does not pose a bar to this court's review. If I could address the waiver of appeal initially. The waiver of appeal in this case, Your Honor, took place before the plea court, which failed to distinguish for Mr. Grant that his right to appeal is separate and distinct from the constitutional trial rights that a defendant automatically waives at the time of a guilty plea. Specifically, after reviewing Mr. Gant's trial rights or the Boykin rights that are automatically forfeited upon a plea, the court right away goes into stating, you also understand that as a condition of this plea, you're waiving your right to appeal. The plea transcripts refute the respondent's claim that the court in any way distinguished the trial rights from the appellate rights. It's simply not supported by the record before this court. The court never uses the terms that are typically found in records where the waiver is upheld, such as stating these rights are separate and apart from your trial rights or that they are distinct from your trial rights. Nor did it explain that unlike trial rights, which are automatically waived, the right to appeal typically survives a guilty plea. And I would just like to note the language in People v. Thomas, which is cited too in our brief, where the court finds that the trial court has a responsibility to ensure that a defendant's full appreciation of the consequences and understanding of the terms and conditions of the appeal waiver is apparent on the face of the record. And again, in cases such as Lopez and Billingsley and Nicholson, the Court of Appeals notes, it's concerned that the language used by plea courts, it's concerned about the language that plea courts use, and it warns that the rights surrendered by waiving your right to appeal are too important to be handled in this perfunctory way. And the standard procedure should always include language that says these rights are separate and apart. And the fact that, in addition to failing to distinguish these two classes of rights, the court also characterized the waiver as entirely foreclosing a direct appeal initially. So on page 8 of the plea transcript, the plea court states to Mr. Gant.
He also says, the court also told him there are certain rights that would survive this waiver of right to appeal, and asked if defendant's counsel had explained those rights to him, and defense counsel confirmed.
That is correct. So subsequently, the court then goes on to state, apparently contradicting its initial statement, that certain issues would survive. But the court does not ensure a knowing and voluntary and intelligent waiver when it creates a record that consists of some accurate and some inaccurate statements about what a waiver is. Importantly, there's no explanation by the court what issues survive a valid waiver, and there's no effort to reconcile this later instruction, which is brief, with the court's earlier statement that the waiver forecloses any review. So there's no explanation to Mr. Gant, sir, that it's not that the waiver entirely forecloses a review of your conviction and your sentence. It's just a narrowing of the issues that you could appeal.
To the extent that there's confusion, doesn't the written waiver sort of clarify that then?
So the case law holds that a written waiver can supplement a court's oral advice on the record. But in this case, what the written waiver does is that it contradicts the plea court's instruction. And so Mr. Gant, who does not have much experience in the criminal justice system, is left to reconcile the court's verbal instruction, the last instructions before the conviction is final to him, and he has to reconcile that with what is in the written form. And so where there is this discrepancy between the court's instruction and the written waiver, there is confusion about what exactly.
Counsel, if we were to find that the waiver was valid, does that not preclude the suppression issue?
A valid waiver would preclude, but in fact, the record shows that the waiver was not valid. And if there aren't other questions, I would like to move forward to addressing the suppression issue.
You can do that on rebuttal.
Thank you.
You may proceed.
Thank you, Your Honor. Andrew Lozidis, appearing for the Office of Darcel Clark, respondent. Good afternoon, Your Honors. It may please the court. Your Honors, the waiver of the right to appeal here was valid. The court did differentiate the trial rights from the appellate rights. In fact, as my colleague just pointed out, that you are aware that in addition, you're also aware, understand that as a specific condition of this guilty plea, you're waiving the right to appeal, separating the trial rights from the appellate rights. The written waiver of the right to appeal was also one that was approved by in People v. Thomas. The judge in this case made sure that the defendant understood everything that he was waiving his rights to, confirmed that he was represented by adequate counsel, confirmed that adequate counsel explained everything to him, and that he understood everything that he was giving up, and then explained what rights did survive the waiver to right to appeal. This waiver is valid, Your Honors. That then brings us to the next point, which is that the suppression issue. So not only is this waiver, does this prevent defendant from bringing up the suppression issue, but on top of that, just before the defendant pled guilty, on page 5 of the plea minutes, well, the court asked him, do you withdraw any previously filed motions at this time? Defense counsel said, yes, there is a pending motion to re-argue that I'll withdraw at this time since the people have agreed to this disposition. So defendant is precluded from not only by the waiver, but also precluded from the re-argued motion.
Would it be fair to say that in the original motion, the defendant alleges that he wasn't engaged in unlawful activity? Wouldn't that be sufficient to merit a hearing?
Well, the issue, though, Your Honor, is that in the initial papers that were filed on June 27th, he didn't provide any factual basis behind the allegations that he wasn't involved in any unlawful behavior.
But it puts you on notice what the claim is, sufficient to be able to go to court, bring the officers, and they would testify as to what the defendant was engaged in, no?
Oh, sure, absolutely. And then, of course, then the people responded to that, and then the lower court found that there wasn't enough allegations behind
Well,
it.
I'm asking you whether the court, getting to the merits for a minute, was that decision wrong in light of what the defendant says? That's all.
No, Your Honor. I think the lower court made a correct finding there. And then after it made its decision, then defense counsel filed the motion to re-argue, which then they had to withdraw when the defendant pled guilty. Therefore, he's precluded. And unless Your Honors have any other questions for me, I rest on the rest of my arguments in my brief.
Thank you.
Thank you.
I have 1 minute, and I'm giving you the 10 seconds he left over.
I just want to briefly address in a little bit more detail what's addressed in our reply brief, which is what motions were filed and at what time. So there is the omnibus motion that's filed by the defense. There's a response from the prosecution. Subsequently, and there are court date stamps to sort of corroborate what I'm arguing here. And so the prosecution files their response on September 6th. On October 4th, the case is on the calendar for a decision, but it's again adjourned for a decision. October 5th, defense counsel files a supplemental motion again, and the court's date-stamped decision falls on October 16th. Again, there is more detail in our reply brief, but the omnibus motion and the supplemental motion, we argue, are both timely and were not abandoned. The motion to re-argue, which is entirely separate, in which defense counsel did withdraw at the time of the plea, we are not relying on in our principal brief or our reply. To address the merits of our argument as to summary denial, here, the omnibus motion—
We're out of time, so we will take your arguments on your submissions, okay?
Thank you.
Thank you. Nadler versus Carmine Limited. You may proceed.
Thank you, Your Honor. Good afternoon. David Berkey, Galatrier and Berkey for Plaintiff Appellant. Your Honor, we know Justice Leibovitz is a good judge, but in this case, unfortunately, he made at least 4 mistakes. I'll go to the first. Okay, the first was his recognizing that in a case where you're challenging the deregulation of an apartment, there is no look-back period that would bar the court from reviewing all of the records that support the rent increases that led to the high rent decontrol or deregulation that occurred here. But once he recognized it, he flipped. He looked at the facts and he said, you know, the deregulation occurred in 2003, but I'm only going to look back 4 years from 2003. He imposed his own limit, a 4-year limit, when we know that the bulk of the rent that was charged from 1994 going at least to 2003 came from the individual apartment improvement increase of more than $600. So when
concede that he was at least correct with respect to the rent overcharge?
With respect to the rent overcharge, he made a mistake there too. That's his second error. Okay, I'll go to that right now because you raised it. So he said, look, he said the plaintiff sitting over there has signed her lease in 2006. And we're only going to look 6 years from 2006 forward. And 2012 has come and gone. So she cannot make a rent overcharge claim because the statute of limitations bars it. Now, that analysis is backwards. If you take a look at CPLR 213A, if you take a look at the HSTPA, they say you can file a claim for rent overcharge at any time. But what's limited is the damages that you can collect on your claim. You can only look back 6 years from the date of filing and collect damages for that 6-year period. So that was his mistake number 2. Then mistake number 3. He didn't take into account the policy of the legislature set forth in the HSTPA, repeated in Chapter 760 of the laws of 2023, and Chapter 95 of the laws of 2024, which is that a court who is examining an overcharge or a deregulation claim, let's talk about deregulation claim, has to evaluate it based on the totality of the circumstances and look at all available records. And what Judge Lebovitz did is he said, landlord doesn't have to produce any records. Even though we had detailed submissions of notice for discovery requests for documents and deposition notices, he ignored it. He said, I'm not going to take a look at anything related to the IAI, which was a terrible mistake. And, Your Honor, if you look at policy again, there are very few tenants who would ever have IAI records, okay? The landlord has them. The landlord has all the records, and in this case, submitted none. No checks, no bills, no contracts, no affidavits.
Are the DHCR filings sufficient?
He didn't produce it in this case on his summary judgment motion, and we looked at the DHCR records, and we didn't see anything like that in the DHCR records. All we got was the report based on the landlord's information given to DHCR of what the rent was that he charged.
It's self-reporting, in essence.
Correct, correct. And the DHCR record says so in big, bold letters. Nothing we're saying here essentially is factual, but it repeats what the landlord told us. All right, so for this case and for every case that follows it, a tenant that challenges a deregulation based on a huge bump, and here it was more than 66% of an increase in the rent, should be entitled to take a look at the records that led to the bump.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. Magda Cruz for the owner, Carmine Limited. Your Honor, Justice Leibowitz, needless to say, made no mistakes on this case. This case is so crystal clear that what the appeal evidences to me is that now a tenant who has been in occupancy as a market tenant for almost 20 years, all of a sudden wakes up one day and says, you know what? Hey, maybe my apartment is rent stabilized.
But under our case law, haven't we held that a rental history can be examined beyond 4 years to determine rent stabilization status?
Yes, and
wouldn't it apply to this case because there seems to be some issue with what occurred here many, many years ago?
So, Your Honor, in fact, Justice Leibowitz did examine whether there was a proper deregulation in 2003. And that was more than...
And how did the owner meet its burden to show a lawful deregulation? DHCR filings, as you know, aren't sufficient, right? Because that's what you're reporting. In cases that we've had in the past, including just one a little earlier, owners submit records.
There were more than just DHCR registration statements. There were leases that were provided in the motion papers. The lease pertaining to the predecessor tenant showed that the rent was over the deregulation threshold, Your Honor. Now, if the question...
But doesn't that beg the question as to how it got there?
Your Honor, if that would be the question, then we are going to be going back 5 years, 10 years, 20 years, in this case, 30 years, to examine a bump in the rent, an increase based on improvements made to an apartment when it was still rent stabilized, and that improvement increase did not deregulate the apartment, Your Honor. The improvement increase raised the rent lawfully, we submit, in 1993, and 10 years later, when that tenant vacated, we have a lawful deregulation because the rent in 10 years went up over the deregulation threshold. There's nothing untoward or abnormal or suspect over something like that. And if there is, then there will not be a single tenancy
But how do we square
in
it?
this
I guess the question,
city that will not be open to scrutiny.
the question is how do we square it with our case law? Because you're saying essentially that there should be a rule, 10 years, 20 years, 30 years, whatever the rule is, that the look-back period doesn't go beyond that. I mean, that's in essence what you're arguing, correct?
Your Honor, the reason why it squares with your case law is because the bump in the rent in 1993 had nothing to do with the deregulation of this apartment. This apartment was deregulated in 2003, and the owner submitted evidence of that deregulation in 2003, and the Supreme Court looked at the leases, looked at the registration statements. That court did not have to now examine individual apartment improvements that had occurred 10 years before, Your Honor.
Is there a case that says that?
Absolutely, Your Honor. I can definitely provide you with that. It is definitely in our brief. Multiple cases find that individual apartment improvements are not subject to examination past the statute of limitations, absent a colorable claim of fraud. The Court of Appeals reviewed this in matter of Boyd versus DHCR, and that is discussed at length in my brief, as well as other cases, Your Honor, because we should not conflate an overcharge, a bump in the rent, with a deregulation. That individual apartment improvement did not deregulate the apartment. The apartment was deregulated 10 years later in the normal course of normal increases that were demonstrated by the registrations and the leases. Your Honors, I submit there was no error in the lower court's decision, and this court should affirm. Thank you.
Thank you. You have 2 minutes.
Thank you, Your Honor.
Can you address that point?
Yes. First of all, what that point is that because we deregulated an apartment based upon high rents, that ipsy dixit proves that the increase in rent was lawful. It's because I said so. My increase, which created a $600+ increase back in '93, that mushroomed every time a percentage increase was added to it, and led the apartment to get to $2,085 and then decontrolled, has nothing to do with whether my IAI was lawful, legal, ever happened. And it's...
But how many years can we go back? Are we going to go back 50 years, 40 years? I mean, they obviously don't have records at this point.
Well, that's not necessarily, I'm sorry, Your Honor. That's not necessarily true. When my clients buy a building, they get all the tenant records of all the apartments in the building. So they haven't said they don't have them. They just said, we just bought the building. And in this case, we would examine the current owner, we would examine the prior owner, we would get all documents that the current owner has, that the prior owner has. We would go to the Department of Buildings and see if anything was filed to support a $30,000 alleged improvement. So far, we've seen none. So the evidence needs to be explored. The legislature wants it to be explored. They don't want a fraud on the agency. They don't want a fraud on the tenant. And unless the legislature puts a time period cap on it, Your Honor, we go back to the beginning.
Thank you.
Thank you, Your Honors.
People versus Anthony Barlo. You may proceed.
May it please the court, Frank Shaw from the Legal Aid Society for Ms. Barlo. 3.5 to 7 years in prison for shoplifting some body wash, toothpaste, and socks is excessive. Now, to be
That's
sure,
not, wait. No. He's not doing 3.5 to 7 for stealing body wash. He's doing 3.5 to 7 for pulling out a knife and threatening the security guard who tried to stop him.
sure.
Right?
I acknowledge
that,
that Ms.
right?
Barlo displayed a knife during these
Okay.
incidents. That's right. And that was actually going to be my next slide, which is that context matters. And I'd emphasize here that in each of these instances, the items that she took were pretty inexpensive, and she displayed a knife only when confronted by a store employee. I think those circumstances largely neutralize much of the danger we typically associate with knives, and in this case, warrant
How
a
does
sentence.
that neutralize it? I don't understand that statement.
She did it more than once, counsel.
Sure, yeah. So I think a couple points in how it neutralizes the fact. One is that, again, these are low-value items. One of Ms. Barlo's statements to one of these store employees was, "You want to die over socks?" I mean, that rhetorical question, I think it shows that we all know no one's actually going to get hurt over these socks because they're just...
We don't know that.
He said, "You want to die over socks?"
We don't know
What if the
that.
person said yes? What would he have done?
Well, I think it's highly unlikely that the person would have said, "Yes, I'm willing to die over socks here," I think, as a...
Do we really have to make that decision? I mean, in this instance, your client was charged with 5 counts of first-degree robbery, and it's anywhere from 9 to 25 years. So in light of that, is the sentence excessive?
Yeah, so I don't think that's actually a helpful comparator, the fact that you have these first-degree charges exposing her potentially 25 or even 30 years if they were run consecutively. I think, if anything, we would expect from the criminal justice system that at a minimum, it would avoid that draconian sentence. I think the more helpful way to frame this is just to go back to sort of the first principles and more intuitions of saying, okay, for shoplifting, but admittedly displaying a knife, what is the sentence that's appropriate there, subject, of course, to the statutory limits and what that sentence can be. And our only point is that, if you approach it from that perspective, 2 to 4 years is still a lengthy time in prison and adequately punishes Ms. Barlo for these incidents here.
Despite the fact that it was, the shoplifting took place in different establishments on different days, during different times. I think I counted 5 altogether. So you have 5 robbery counts. Maximum on the top end is 125 years. And you compare that to what, 3.5 to 7?
Yeah, so again, I just want to push back. I don't think that comparator is that helpful. It's kind of like the Aaron Swartz case that we cited
Not
in
helpful to you, perhaps, but look.
Yeah, well, I
I
guess...
get it, all right? And these cases are disturbing because people are doing serious time, as you say, for really inexpensive items, okay?
Right.
So for me, the issue is just don't pull out a weapon. Then we'd be dealing with a petty larceny. Okay?
That's right, yeah.
So the fact that we are in elevated sentence land is as a result of your client's actions in pulling out a weapon.
And threatening to use it.
Sure, but again, just going to the overcharging here, if I may, just like to conclude, pointed to how this can go awry sometimes. In the Aaron Swartz case that we cited in our brief, there, Mr. Swartz, he faced up to 35 years in prison, and the prosecution offered him 6 months. I'm sure they thought, wow, this is quite favorable to you. You should accept it. But tragically, he didn't. He thought that was too much, and he committed suicide. So again, this kind of reasoning can easily be abused to make any kind of sentence imposed seem like an act of prosecutorial grace.
Okay, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. Jennifer Cavallas for the people. Defendant's excessive sentence claim is foreclosed by her valid waiver of appeal. But in any event, defendant's bargain for sentence was reasonable in the light of the sheer number of crimes and the violence that she used when carrying out these crimes. Defendant negotiated a very favorable sentence of 3.5 to 7 years in prison in exchange for her plea, where, as Your Honors have noted, she could have faced a maximum of 25 years on a single count and a minimum of 9 years on a single count when she was facing 5. But for this plea, she received just 3.5 to 7 years, which is less than the 9 years that she could have faced on one count after trial. And the defendant does not present any circumstances on appeal that would warrant a sentence reduction here. The sentencing court was fully apprised of her mental health concerns, her indigency, and all the struggles that she is facing.
Sort of the low-value items, I mean, just everyday nothing items. Is that something we should take into consideration? Putting aside the issue with the knife, but...
And the fact that you know, these stores, their owner management policies is don't chase a shoplifter. Don't place yourself in danger, right? As he said, you're gonna get stabbed for a pair of socks. I mean, they steal. You call the cops. We have had many of these cases with low-level items. I mean, these people are stealing under $20, and they're doing serious time.
Yes, absolutely. I think the difference...
Because the security guard confronts them.
Yes, absolutely. Those circumstances present a far different circumstance in here because I don't think you can remove the violence that occurred here. Showing and displaying a knife and saying things like, do you want to die today or not today? That's very difficult as the person that's on the other end of that to receive. You have to consider, and as the court did here, the effect of hearing those words and seeing a knife. You know, a store clerk, that's not something that they expect on a daily. And to hear something like that can be really detrimental to somebody's well-being and safety. And that's something that this court should really consider. And the people recognize the nature of the items here indicate you know, the defendant's indigency here, you know, we're talking about shampoo, but that does not take away from the fact that displaying a knife is very detrimental and very unsafe to the people who may have witnessed that, as well as the victim on the receiving end of that. And we ask Your Honors to consider that when you, in affirming the defendant's sentence. If you have no further questions, we ask that you affirm.
Thank you. Counsel, I'll give you her leftover 15 seconds.
Thank you. So just briefly, a couple points. You know, I think you already discussed some of these. There are a lot of store policies, like you said, don't confront people with shoplifting. And I've heard of instances where employees who violated this policy were later fired. So had they not confronted Ms. Barlo, she would have shoplifted and there would have been no display of a knife.
She wouldn't have displayed her knife, so it's the store's fault.
But it's obviously, it's not, no, it's not their fault. You know, obviously, she still bears some responsibility for this, and I think that's adequately captured by 2 to 4 years in prison. And then just very briefly on the appeal waiver point, you know, I think even by the lenient standard that it's often judged by these courts, it feels even that, you know, the trial court referred to Ms. Barlo's generalized right to appeal. I think that's just plainly insufficient here. And if the court has no other questions, we would ask that you reduce your sentence.
Thank you so much.
Thank you.
Okay. Crandle versus Equinox Holdings.
Good afternoon, Your Honors. May it please the court. My name is Ori Nazarian. I represent plaintiff appellant Shane Crandle. It is undisputed that Equinox owed a duty to Mr. Crandle and to other members of the club. Once that duty is established, the foreseeability determines the scope of the duty. In other words, what kind of measures Equinox would have to implement to discharge.
Well, in this case, the Supreme Court seems to say that since there was, with many of the complaints, most of the complaints, there was consensual activity, and that somehow makes it weaker. What's your view on that point in terms of the prior incidents and the incident that occurred to your client?
Sure. So, I mean, maybe there was some consensual activity between two people who were engaging in sexual activity in the steam room, but it wasn't consensual to the victim who complained about the event. And so what my client experienced is almost identical to what was complained about prior. And those prior complaints, whether it was one person masturbating or someone engaging in sex with somebody else, is exactly the risk that my client ended up facing by going into the steam room. And the fact that he was physically touched by his assailant just shows how serious this kind of event can be.
Do you think that it's foreseeable that there would be an assault? Because this was an assault.
Yes, I do think it is foreseeable, but...
Or at least is it an issue of fact for a jury to determine?
Absolutely. That was my next thing, is that it is under Jacqueline S., the foreseeability, the prior complaints have to be similar, reasonably similar for the present attack
Not
to be
identical.
not identical.
And we
Here
have
there
that 13 prior incidents. Here,
Yes, or 15, I believe the number was. Plus the documents showing that they were aware of the issue. They even put all of these kinds of conduct under the umbrella term of inappropriate steamroom behavior. So they knew. It's not like they're going to say, oh, we think a sexual assault is something we need to guard against, but not one person masturbating in a steam room.
What about the second prong of the motion, and that is that what more can Equinox do? We have a policy, we can't put a camera in there, we have a locker room person who goes in and periodically, I guess, inspects. Has a prima facie been made out on that aspect of defendant's motion?
No.
Why?
No, because, well, first of all, it's a jury question. Because really what I believe is reasonable doesn't matter, and what one judge believes is reasonable doesn't matter. You need a jury for that. So, I mean, I could list, and I think on page 43, I did list a whole bunch of different measures that might have prevented this from happening. The zero tolerance policy was illusory. It didn't mean anything because the inappropriate steamroom behavior medallia template confirmed Equinox had to witness it. So the zero tolerance didn't really mean anything.
Is there anything in the record to suggest that when this activity was occurring, when there were prior complaints, that Equinox called in the police to say that this is happening in the steam room?
No, they did not. And in fact,
did they submit anything saying who checked the steam room and at what time?
no logs, no records were produced showing that they took any measures to actually check. And Ms. Binsky submitted 2 different affidavits, Jackson affidavits, confirming that Equinox does not have a single police report or incident report related to inappropriate steamroom behavior, in this case or the GB case.
And in this case, he runs out and says, hey, this guy did this to me. They revoke his membership, they let him walk out, the police is not called.
Correct. The police were, to my knowledge, never called, and there was no incident report for Mr. Crandle's complaint.
With respect to the individuals, Hammond and Tavares, what, if any, duty did they breach?
They knew what was happening.
In the Greenwich, in the
Greenwich
steam room? Were they connected with that facility?
They signed up Mr. Crandle, and I know
Wait
that...
a minute, I'm just, be specific.
So Mr. Hammond signed up Mr. Crandle. Mr. Tavares knew that there had been prior complaints. I'm not sure if he knew that they were in the Greenwich Equinox.
So how would he be responsible for that?
Isn't he acting by signing up? Isn't that what people do? You sign up members. He's acting in the furtherance of his employer's business, signing up new members. Correct?
The question would be whether he had a duty to disclose to Mr. Crandle, we know that this is happening at this location, at other locations as well, and you shouldn't be signing up, or...
Wait. What? Come on. You expect the employee of Equinox, while talking to a prospective new member, signing up for the gym. Oh, by the way, we do have this problem in the steam room. You may not want to sign up here. Come on.
That's not going to happen.
And it's not even in the same not even in the same premises. It's different premises.
Correct. I don't expect that that's what those individual defendants would have done, but I think that's something that they could have done.
All right. We'll hear the other side now.
Thank you.
May it please the court. John Garcia on behalf of the defendants' respondents. On this appeal, plaintiff appellant Shane Crandle repeats the same arguments that he made below, which the lower court properly rejected when it granted summary judgment to the defendants on all claims.
And that's why we're here.
Yeah, so tell me what What exactly was the requirement of the locker room attendee vis-a-vis the steam room? Exactly what their requirements were with respect to that steam room?
The locker room attendant is required to periodically check the steam room.
And what does that mean periodically? Every 10 minutes? Every 15 minutes? Every hour? What are we talking about here?
It's not a set time, Your Honor.
Oh,
Do you
okay,
keep any
so-
logs?
It's not a defined time. It is periodic. It
Why
depends
not?
on their duty. Because it
Why
depends-
not?
Because they have a multitude of duties to perform in the locker room.
Yes, but there's only one spot where somebody could get raped, right?
Your Honor, that has never happened. No one has been raped, and that has never happened before. There's never been a violent crime committed in the steam room before, or even alleged.
You know, I don't know, having a naked man who is masturbating wrap his legs around my legs and preventing me from leaving the steam room, to me, is a violent act.
Yes, Your Honor.
I don't have to end up bloodied to perceive that someone has perpetrated violence against me. So, sir, the act upon Mr. Crandle was a violent act.
Agreed, Your Honor. That's a
Okay,
heinous
so
violent
then tell
crime.
me, what did Equinox,
never-
counsel, I'm talking.
Yes, Your Honor.
Okay, so tell me what Equinox did when Mr. Crandle comes out of the steam room upset and says, this man is masturbating in there and he just assaulted me. I thought he was gonna rape me. That's what he said, right? Was the police called? That was a crime. So did Equinox protect its member and exercise the proper duty of care by calling the police in response to a crime committed on your property?
Your Honor, Equinox did not call the police, but there is no duty under the law for Equinox to call the police.
No.
Mr.
A
Crandle.
crime is committed against someone in your establishment. They complain about the crime committed against them. Because I believe, having practiced criminal law, that it is against the law to publicly expose yourself, and certainly to masturbate in front of someone else that you don't have a relationship with, right? So the fact that this man in the steam room masturbated in front of Mr. Crandle, he subjected him to a crime. A crime that your establishment was aware happens a lot in that steam room.
Your Honor, it does not happen a lot, but even beyond that, there's no evidence.
Hold on a second. I think we all unfortunately had to go through those incident reports. How many were there incidentally?
13 incidents, Your Honor, over the course of a 6-year period preceding the incident. And Your Honor, none of those 13 incidents involve CB, the alleged assailant in this case.
So it has to be the
Doesn't
same one?
matter. Counsel, one of the incidents in April 2013, a member made a third attempt to alert the club to the fact that he felt he was sexually violated in the steam room at Greenwich. On July 3rd, 2017, a month before the plaintiff's incident, Equinox received a complaint about the steam room and locker room being too sexual, the member having been masturbated at twice and him being sexually harassed. Does it matter that it wasn't CB? Would you put on notice? People are going to the gym to work out, not to get sexually assaulted in the steam room.
Yes, Your Honor, Equinox does not want this behavior. Equinox had reasonable measures in place to prevent this behavior.
What reasonable measures?
What did you submit?
We asked you. What is the, look, you can't just say locker room attendant every now and then peek in and make sure somebody's not being sexually abused or somebody's not in there having sex with another member or masturbating all over the steam room, okay? You know this is happening in your establishment. This is not a off-shot thing. Your own workers say, oh, this happens all the time. So I don't understand how you think that by saying, oh, just check every now and then, that you have somehow fulfilled your duty to keep a safe premises.
And since we don't have any records, we don't know if that policy of checking every now and then is even followed.
Your Honor, first and foremost, this is not happening all the time. And this is This incident that we're talking about, as Your Honor pointed out, is a violent, heinous attack. It has never happened before inside the Equinox steam room.
It has
period.
escalated, counsel. It has escalated. At this point, he wraps his legs around this person not to let him leave. What are you waiting for? For something to get further on?
Your Honor, that had never happened before. That is what makes it unexpected and unforeseeable that someone would engage. There's no evidence that someone who masturbates in public is likely to attempt to rape someone. That is not in the record. There's no evidence that that is the harm that is foreseeable here.
Isn't that a question for the jury to decide as to whether or not it's foreseeable based on the activity that the incident reports state, whether this incident was foreseeable?
And you know, I gotta tell you, all right, and just food for thought for Equinox, right? If you know that you have members who occasionally go into the steam room to masturbate, you are permitting behavior that can create an explosion in that steam room. Because the wrong person goes in that steam room and is highly offended by that, you could have somebody get beat up for what they're doing. So, a word to the wise, they should revisit their policy and figure out something else, because this ain't working. This is not working. It keeps happening. And eventually, someone is gonna get seriously hurt, either sexually assaulted, or the person masturbating is gonna get beat to a pulp. Something very bad is gonna happen. And all the warning signs are there, they're flashing, big red lights. Okay, I know this isn't you, okay, I need your company to understand the potential danger that exists in this situation. All right, I will give you another minute if you have something else you'd like to say.
Yes, Your Honor. Just very briefly, the law requires there to be a reasonable awareness of the need to control specific third parties from engaging in foreseeable criminal behavior. None of the prior incidents put Equinox on notice.
Why? But wait a minute. The actions of these individuals, while they may have been consensual among themselves, the person using the steam room certainly didn't consent to be violated, to have to see that. So it's not a leap of faith to say this is happening and it could escalate, or at least it's a jury question at the very least, right?
Your Honor, in Maheshwari versus the City of New York, the Court of Appeals ruled that low-level offenses cannot be used to impute notice of a violent assault that occurred in that case. These incidents are not similar. They are not similar to the incident that occurred to Mr. Crandle, unfortunately. And that, in and of itself, is why Equinox does not have a duty to prevent that exact behavior from occurring. And there's no evidence of this assailant ever engaging in this behavior before at any Equinox facility.
Is there a case that says that it has to be the same assailant for there to be notice? I don't think so.
Would the precautions that Equinox took, if they were following through on their precautionary measures, would that have dealt with this issue? Could he have been protected if they were following through with their checking of the steam room?
So, Your Honor, that actually brings up another point, that Equinox could not have prevented this incident from occurring because they cannot have someone inside the steam room all the time. That's the only way that you could have prevented this sudden and unexpected attack from occurring.
You can have someone go into the steam room every hour.
But even if it didn't occur at that exact moment, there would have been no way to have prevented this incident from occurring. That is the issue here.
Also, there was no incident report for this particular case, right?
There was no incident report filled out. That is correct.
So how many other incident reports have not been filled out?
Your Honor, there is no requirement for an incident report to be filled out. The fact that we are aware of these prior incidents is because they are documented, because it's being reported in some fashion. It does not need to be a specific incident report. And in this case, in regards to the police, there's no duty to call the police, and CB did not report this crime to Mr. Crandle did not report this crime to the police. In any case, In addition to having a sign outside the C-room door that advises member of a zero tolerance policy towards inappropriate behavior and warning that offending members will lose their membership, locker room staff immediately reports incidents to management as soon as they become aware of it, which is what happened in this case. And canceling the membership of anyone found to engage in that behavior are the policies that and procedures that Equinox has that are reasonable under these circumstances to prevent inappropriate and lewd behavior, which the court below correctly found, which is why this court should affirm that decision and judgment.
Thank you.
I just want to rebut a few things really quickly. Maheshwara, the Court of Appeals case, deals with an attack at a parking lot during a festival. It's very different. It's not a repeated thing of members coming in and making the same complaints over and over again. That's the first thing. There is no case that states that the specific assailant in this case has to have a criminal propensity. In fact, Jacqueline S., Burgos, Nalin, and Miller all involve unidentified assailants. Hedges, the one where the youths threw a shopping cart over the mall balcony, no criminal propensity before, and they still found that there was a duty. And finally, the issue with the police reporting these things, actually canceling members, even if Equinox didn't witness it, by actually executing those efforts and making reports, those are the kind of measures that maybe would have deterred this continued behavior. But the complete absence of it, at least, is enough evidence for a jury to say, well, you didn't do enough.
Thank you. Anonymous versus anonymous. You may proceed.
Good afternoon, Your Honors. May it please the court, my name is Heidi Talentire. I represent the appellate defendant, Vladimir Schendelman. The lower court improperly retained this case in New York when plaintiff has lived in New Jersey since 2020. Respondent plaintiff used her work address as the basis for jurisdiction, which is a procedural defect in the commencement documents. Respondent plaintiff admitted that she would never return to live in the Bronx residence, and the respondent plaintiff cannot state a cause of action for divorce that would permit a divorce to proceed in New York. Appellant moved to dismiss.
Didn't your client enter into a postnuptial agreement that would place the jurisdiction of this situation in New York?
So, Your Honor.
And why shouldn't we honor that?
So, Your Honor, for a couple of reasons. The first is it was for an uncontested divorce that the language in the postnuptial agreement says this is clearly a contested divorce action. Secondly, if we allowed litigants to contract into whether or not there is a cause of action that doesn't otherwise exist given the durational residency requirements of the state of New York, then subject matter jurisdiction would suddenly be waivable and would be part of.
Counsel, that's a really difficult argument here in light of the fact that your client is an attorney, right?
So my client
he
is an
knew
attorney?
exactly what he was signing, exactly what he was getting into.
So, Your Honor, that is a subject for a motion to dismiss or to set aside the postnuptial agreement. However, with respect to this issue of residency, durational residency, and whether or not domicile existed in the state of New York for these particular parties, that goes to the statute. And it is certainly our contention that that's not waivable.
So in this instance, why wasn't Supreme Court correct? The wife works in New York, she votes in New York, she has a New York driver's license, she has a gun license from New York, all her medical doctors are here, and also significantly, wasn't the New Jersey house put up for sale?
So
prior to the postnup agreement.
And that was a house that was purchased during COVID, where the family needed more space because everyone was working from home and the girls, the daughters were at home in school, et cetera, and they needed more space. And according to the papers, other family members, whatever, also came and stayed with them from time to time in New Jersey. And clearly, these are people of means, so that purchasing a property in New Jersey is just purchasing a property in New Jersey. She didn't sell the New York house to buy the New Jersey house.
And I thought it was undisputed that the purchase in New Jersey was for purposes of investment.
So there have
I
been
know it's
three
three of us,
questions by
sorry.
three different judges.
Yeah,
so
you
I'm
can
happy-
hit them whichever order you want.
I'll hit, I'm going to try and hit all of them, Your Honors. So with respect to why, the plaintiff respondent has kept a gun license, which is a violation of rules and laws. She has alleged to have voted in New York when she admits to residing in New Jersey, yet she filed joint tax returns in New Jersey. She has changed the vet to New Jersey. She changed her pharmacy to New Jersey. They became members of the local New Jersey synagogue, and I have record sites if you need any of these. She even opened a New York, Jersey office for her biotech company where she's the CEO so that she could use that for her convenience. And with respect to whether or not the parties needed more space, well, their residence in Riverdale is not some small home. It is quite, by the standards of New York, quite large. It's on a double lot. Additionally, they had gone then to the Hamptons during the first part of the pandemic. Then they said, oh, well, now we're going to get a palatial place in New Jersey. And when they moved there, did they believe that it was a good investment? They did. But again, they moved there to permanently move. My client stated, and that's all in the record, that they did not want to remain in New York any further or any longer. The plaintiff...
That was a disputed issue of fact. The court held a hearing and then made a determination, presumably in part based on credibility of the witnesses. Why shouldn't we defer to the issue determination of the court?
So the court did not hold a hearing, Your Honor. That is something that's a disputed issue. I asked the court multiple times to please have an evidentiary hearing, and he said, I'm first going to ask a few questions, and I'm going to decide after that whether or not I'm going to have an evidentiary hearing. And one of the requests for relief that we are
Were the
asking...
parties given an opportunity to testify under oath?
Yes.
Was there an opportunity to cross-examine witnesses?
No, there was not. To put this in context, we had...
You weren't able to ask any questions?
I'm sorry.
You weren't able to ask any questions?
Of the other party, no.
Okay.
So the judge asked the plaintiff questions, and my client came into court after. So this was on for oral argument for 4 motions, Your Honors. So when we arrived, I was only hired to represent the appellant defendant for the motion to dismiss. But there were 4 motions on. My client was late. He landed at JFK. He was a half hour late. The judge said, if he doesn't show up, I'm going to dismiss his application that's before me requesting a dismissal. He did ultimately showed up, as Your Honors undoubtedly saw. I apologized profusely many times. That was part of the record. The judge started asking questions of the plaintiff respondent. During this oral argument, I kept saying, Judge, I would like a full evidentiary hearing. I'd like to sit down for one. And he said, Judge Katz said, I will consider that after I hear and decide whether or not that's necessary, after I hear from these parties. He asked a few questions of the plaintiff. Then when my client arrived, he said to me, okay, you can ask a few questions of your client. Afterwards, he said, I have enough now. I don't need to get to what your client said because I'm just looking to what her subjective intent was. Now, as Your Honors accurately stated, there also has to be indicia of whether or not the domicile has maintained. She stated, I'm never moving back into our New York residence in the Riverdale. I'm never doing that.
That's not what she said before the court when she was questioned by the judge. She said that she always intended to return to New York. That's why she kept...
said, I've always intended to, at some point, move to the Upper East Side. She said on the record...
That's New York.
11 and 12. Yes, they didn't live there. They don't have a residence when she filed for divorce. They did, there was
Are you
no place
suggesting,
that
are
she
you
was returning
suggesting,
to.
are you suggesting that she couldn't have afforded a residence on the east side of New York?
She absolutely could. She, in fact, just 2 weeks ago paid off a $2 million loan that was also part of contention on other motions in this court, not in this court, sorry, in the lower court, and she paid it off about 2 to 3 weeks ago. We found this out on Friday. This is both of these parties have significant amounts of resources. If she wanted to be in New York, she would be. If she wanted to be on the Upper East Side, she would be. She has received millions of dollars in compensation since she filed for divorce. She filed for divorce in New York while living in New Jersey, while saying she's not returning to the party's New York address, that it's going to be some other hypothetical address.
But that's okay, counsel. If this couple has decided they're getting a divorce, she has a right to move wherever the heck she wants.
She does, but Your Honor, months have passed.
You on rebuttal. We're way over time. I wanted to give you some latitude, but got to get to the other side, all right? All right.
Good afternoon.
Good afternoon.
Robert S. Michaels. I am here for the respondent plaintiff in this matter. I think
Counsel, was it a hearing?
there was a hearing.
Well, before we say, no, what were the parties sworn?
The parties were sworn.
And who got to ask questions? Just the judge?
The judge asked questions of my client. I said that there were a number of matters that were raised improperly on reply that we wanted to address. The court said, well, let me ask your client some questions. Asked my client some questions. Asked me what were those matters that were raised on reply. I addressed those. I did not have any further questions.
Was there an
from my
opportunity to
client.
cross-examine witnesses?
Excuse me?
Was there an opportunity to cross-examine witnesses?
There was absolutely. As a matter of fact, counsel for the appellant defendant specifically said to the court when her client walked in, I would like to ask him questions. And I think it's on page 18 of the record. And she was allowed to ask her client questions, anything she wanted to ask her client. When
Was she,
the court,
was she given an opportunity to ask questions of the plaintiff?
She wasn't. She didn't ask to.
She did not ask.
In
for an
other words,
opportunity?
the court. She asked the court if she could ask questions of her own witness, and
Did
she
not
was given
ask.
that. At the end of the judge's questioning of her witness, he said, "Is there anything else to counsel?" And she said yes, and she referred back to her client to ask questions. But at no time during that hearing did she say, I have questions that I want to ask of the other party. And under Lax, the court is directed to hold a preliminary hearing. So there's a lower court decision. The First Department said, we're sending it back. There should be a preliminary hearing. And that's exactly what happened here. In Black, the court said, we don't have to hold a hearing if there is no controverted facts. There are no controverted facts here. Counsel conflates two things. My client is not a resident of New York. She did not claim in her summons and complaint that she resided in New York. She put down on her summons the address of her work, which is in New York. She said she was a domiciliary of New York. You don't have to have a residency duration to be a domiciliary. The cases that are cited for domiciliaries don't talk about where people live. They don't have a residence, even though she had a residence in the Bronx. It is true, she did not have an intention of moving back to that Bronx residence. She had an intention, and it was her clear intention that she was going to move back to New York as soon as her younger daughter graduated SCR and started college. In pursuit of that intention, she agreed with her husband to put their forever house, according to him, on the market for rent, for sale, which she did in August of 2023. The house was on the market in Englewood. According to the appellant, that house was purchased because it was an opportunity. He disputes whether people came to move in, but he doesn't dispute whether all these people were there and needed a place to live. His daughters, her nieces, and his nieces, an elderly aunt, everyone came to live in that house. They put all the accoutrements of life were there. the fact that she didn't give up her New York driver's license, the registration of her car, her handgun license, her voter's registration. She had the indicia that she intended to move back to New York, and in fact, that is what she intended to do. See, my light is on.
Do we look at the post-nuptial agreement in this situation?
The post-nuptial agreement provides that the matter will be, so it's a jurisdictional selection clause, venue selection clause. It says an action will be brought in New York. Counsel said that it would be an uncontested divorce. Well, they resolved all financial issues in that post-nuptial agreement. New York has now implemented 237 of the domestic relations law, which is the irretrievable breakdown of a marriage. It has been determined that you cannot dispute a party's state of mind. So that is an uncontested divorce. So if we want to get caught up on the word uncontested.
So if the financial issues have been resolved and both daughters are already in college, what's left to?
Implementing the provision, the financial issues have been resolved by pursuant to the postnuptial agreement.
Okay.
Implementing that postnuptial agreement is not an easy task.
Okay.
And in fact, the appellant in this matter is contesting the validity of that postnuptial agreement. So obviously there will be litigation.
Okay.
As a
So
side
we'll
note,
see you again.
as a side note, what's interesting about that is it's a New York postnuptial agreement signed in New York, governed by New York law, that is supposed to apply New York law. Where better to do that than in New York?
And what is the inconvenience to any, has there been alleged any inconvenience to any witness or even to the defense?
You mean for the forum non-convenience ground, Your Honor? Well, Mr.
For that faraway land called New Jersey.
Lives in Miami. So, and the court, in its discretion, the lower court, has ruled that the matter should stay here. So it's rejected by implication any claim of forum nonconvenience, and there is none, because there's the only witnesses that would potentially, as Your Honor has pointed out, that would potentially be testifying here beside the parties might be the attorney that drafted the postnuptial agreement, and he's a New York attorney, and he's here.
Thank you. Okay, you have 1 minute.
So although counsel stated that plaintiff did not say she is a resident of the state of New York, I would refer the court to page 151 of the record. Her verified complaint, second, plaintiff is a resident of the state of New York and has been so for a continuous period, a continuous period of two years immediately preceding the commencement of this action. Again, procedurally, there are defects in these commencement documents, both using the address of the New York office, where she does not reside, she works, as well as stating she's a resident, which we are hearing and have heard repeatedly. She is not a resident of New York. She also, with respect to that gun license, that in and of itself may be a crime that she kept it here. She cannot just transfer her carry license to New Jersey. She states that her that her New York license is something that should be indicia that she continues to be domiciled here. But that license is for her to have that gun based on the Riverdale residence, which she states she's never returning to live. And so, and Your Honors, with respect to forum non-convenes, that was not addressed at all by Judge Katz. And so certainly at a bare minimum.
There was nothing in the record to support it either. Right?
But
I mean, your client doesn't when you claim that a action should be moved for forum nonconvenience, you have to state who the witnesses are that would be inconvenienced, etc.
So
I didn't
Your
see any
Honor,
of that.
the accountants are in New Jersey.
But was it in the papers?
So yes.
Does he outline it in the papers?
Yes, Your Honor. It's in there. You will see it. It's in our forum non-convene section. And if you have any further questions, I'm happy to answer them, but I have my red light. Thank you.
All right. Thank you. Sobrianes. People versus Sobrianes. Did I say it right?
He goes by Ernesto Sobranes.
Sobrianes, okay. Okay, you may proceed.
Noah Breslau for Mr. Sobranes. Mr. Sobranes asked this court for a sentence reduction for his addiction-driven burglaries of commercial entities long after they closed, where there was no confrontation and no one was hurt. Mr. Sobranes' substance use disorder developed when he was a teenager, but importantly, while in pretrial detention, for the first time, he embraced the importance of treatment. Mr. Sobranes took voluntary and impactful steps towards achieving durable abstinence. Those included medication-assisted treatment, participating in a voluntary substance use treatment program that included both counseling as well as group peer work, and explored whether counseling for depression would be appropriate. This programming was so important to him that he risked judicial ire by asking 2 different courts to postpone sentencing so that he could finish this programming. He did so without any benefit as part of a plea. He simply was interested in taking responsibility and leaving prison and jail a healed man. There is clinical and empirical research that people who are invested in treatment have better outcomes. Mr. Sobranes is well positioned to continue the journey he began in custody because he has no history of housing instability. He has family that cares deeply about him and who he is invested in repairing a relationship with. And he has a long history of working trades as a result of his various credentials. And I think it's very impressive that despite not finishing high school, while in custody, he has taken advantage of the opportunities afforded to him and has earned not 1, but 2 college-level degrees. In addition, there is no valid appeal waiver in this case. The appeal waiver was botched. The colloquy failed to educate Mr. Sobranes that he's giving up something more than is ordinarily forfeit as part of the plea. The judge implied there would be a total bar on any further proceedings, and that is, of course, not true. Mr. Sobranes, I think that in their opposition, the prosecution points out that the judge does say that he's giving up rights that are separate and distinct from the right to a jury trial.
Yeah, I thought this was one of the better ones. So I'm surprised to hear you say that.
You have more exposure than I do to these, but from my perspective, there are several flaws. I mean, I think, no one says at the outset of the hearing, the prosecution is insisting on an appeal waiver. That doesn't come up at any point. No one makes clear to Mr. Sobranes that as part of his particular plea bargain, he is giving up a subset of claims on appeal. Instead, what the court says is, this will be the end. And that is not true. Mr. Sobranes was not told.
Yes, but he goes, you see, my note is good waiver. Okay? So he went through all of the necessary, things we look for. Did he say this? Did he say that? Did he cover this? And I have like check marks on all of the items that I'm looking for each time I review one of these issues.
So let me disabuse you of that. I think, here's a great example, right? The waiver of the right to appeal does not extinguish all claims. There are a subset of claims that persist despite waiver.
Right.
None of those are discussed. There's no discussion of the residual rights that would be available, including the invalidity of the waiver or the involuntariness of the plea.
Okay.
There's no discussion about the right to appellate counsel. And I think it's interesting to consider Mr. Sobranes' criminal history. This is someone who has taken appeals after going to trial. So there's not sort of
He has a lot of experience. He's got over 22 convictions. So this is not a novice to the system.
The convictions betray the complexity of his addiction, and I think this is...
Yes, and it also portrays his experience with the system.
Well, but there's no
right?
evidence...
It's a different situation with somebody who's first-time arrest, and they're in shock at everything that's being said in the courtroom, right? We've seen that. right? As opposed to somebody who's, I've been here before, okay?
So I guess that's totally true that he has been subject to criminal proceedings before and he has taken appeals, but the cases that he's taken appeals, he had an attorney after trial to challenge the trial. And there's no indication that he's previously validly waived his rights on appeal. And so this is, it's unclear whether this is a new set of issues for him.
Okay.
And
I'm gonna let you talk after. We're way over the time and you'll have a minute on rebuttal.
Good afternoon, Your Honors. My name is Grace Fee, and I represent the people of the state of New York. For the reasons we argue in our appeal, I would submit that the defendant's entered into a valid appeal waiver that forecloses review of his excessive sentence claim.
But isn't counsel right that the court failed to note that certain rights survived the waiver?
You mean during the oral colloquy?
Yes.
I don't think, I agree that I don't believe that the judge expressly went into
You're
that.
saying that the written colloquy corrected that, and also in light of his extensive experience in the system.
Correct.
Sufficient.
Correct, yes, based on those totality of circumstances, that's correct, exactly. And I don't think there's a dispute that the written waiver does go through the rights that he still retains and then the rights that he's giving up, which includes, it specifically says, the right to challenge the excessiveness of his sentence.
If we were to find that the waiver is not valid, why is the sentence not excessive?
Your Honor, I would submit that the sentence here, which was negotiated, of course, was really quite fair for several reasons. First of all, he did receive the minimum sentence for the 3 burglary convictions. He received the minimum sentence of 2 to 4 years. They could have all been run consecutively to each other, which would have then amounted to 6 to 12, but he got 4 to 8. Two of the sentences were to, 2 of the terms, excuse me, were ordered to run concurrently. The third was ordered to run consecutively with the other 2. Also, I would note that, taking into account that the defendant did commit these robberies, these burglaries, while on parole for a prior felony conviction. Also, he received the benefit of having his sentence, in this case, run concurrently with a 3 to 6 year sentence he received for a burglary conviction in the Bronx. Which, by the way, I would note that he did enter into a appeal waiver on that one too, just a month before. So again, if this goes towards whether he understands what appeal waivers mean, I think that has some bearing on in this case too. And also, as the people point out in our brief, the defendant does have quite a lengthy and a serious criminal history record, which includes about 22 convictions, half of them for felonies. And so I think for all of those reasons, I think that—
What about it? It all appears to be drug-related, right? So he has a substance abuse issue. He is in a program. Is that something that we should take into consideration to determine whether or not it's excessive? And
Your Honors can certainly do that, of course, but I do think that I would submit that the court below here did take that into account, and that was, I believe, a little bit of all a part of why in this negotiated plea and sentence that the defendant got, I think, a really very quite fair sentence here that I think just doesn't warrant a further reduction, given all the reasons that I just also stated about his criminal record and the fact that it was also running concurrently with another conviction, felony conviction from the Bronx. So we would just submit that the sentence here should—
Was that other conviction in the Bronx also for a burglary?
Oh, I'm so sorry, excuse me?
Was it also for a burglary?
It was, yes, for a burglary conviction.
That would be burglary number 7.
Correct, that's right. Unless there are any other questions, I'll rest on the arguments in our brief. Thank you so much. Bye-bye.
You have 1 minute.
Sounds to me like 4 to 8 for 7 burglaries is not that bad.
It could be worse.
It could be a lot worse.
But I think that the issue here is whether he has been punished enough with 5.5 years in prison. Mr. Sobranis was contrite and understood the need to change his ways when he pled guilty and took responsibility before indictment. And 5.5 years, turning 50, one of his kids graduated high school. All of this is enough to cause a man to seriously reconsider his path.
And maybe all of this was also considered by the court in going along with the 4 to 8 sentence for 7 burglaries, spanning 2 counties. during different days?
The premise was for sure before both trial courts, but these issues were not pressed with the same vigor as we present in our appeal, just by the nature.
Was there a pre-pleading memorandum in this matter?
No, it was in the Bronx.
In the Bronx, they had a pre-pleading memorandum.
Yes, and then this case proceeded very quickly. But I want to just,
You're out of time, so I'm going to give you 30 seconds, okay? It's been a long day.
Of course. So this court can reduce sentence by running all 3 counts concurrently. There would be a controlling sentence of 3 to 6 years in an unappealed matter, or this court could increase the sentence on each count to 3 to 6 years and run them concurrent. Both of them would show acknowledgement that Mr. Sobranis's blameworthiness is mitigated by his addiction and that he took voluntary and impactful steps towards rehabilitation on his own. Thank you so much.
Thank you.